petitioner, and S.H. Bora learned additional people. I'll record your objection also if it's allowed. Let me think about it a little bit. Invoking section 483 BNSS. The petitioner so and so is seeking regular bail in connection with Mongoldoy PS case number 208 of 25 under so and so section. He was arrested on 12/11/2025. The it appears that after the unfortunate incident of bomb blast in the national capital Delhi, leading to deaths and injuries, the petitioner made a social media post as follows. Subsequently, he stated to have made a clarification and apologized for the comment as follows. The social media post was on which date?
My lord, 11th.
10.
So on the same day he asked the clarification on the same day.
Incident was on 10th, the same day, my lord, within 11 hours, my lord. It is
He made the post on which day? It is not available here.
It is not available, my lord, but it will have to be on 11th, my lord, because the FIR was lodged on 12th.
On 11th, it is contended that it was on 11th. Subsequently, the FIR giving rise to the present case came to be lodged on
12th.
12/11/2025 with the allegation that the present accused and others posted comments on social media abetting, supporting and abetting the terrorist attack on 10/11/2025 in Delhi, which was perpetuated by terrorist groups linked to Pakistan and leading to deaths of innocent people. It is alleged that they are linked to a banned terrorist organization of Bangladesh, which also is having some roots in Assam. It is alleged that the accused persons are having understanding with this organization, and in this backdrop, they are making such comments supporting such acts. It is content that though an elaborate narration making allegations has been made in the FIR, but it is the social media post of the petitioner which has led to lodging of the FIR, and for which he has also rendered clarification and apology. The social media post has been referred to also in the FIR. Perusal of the case diary is deemed necessary, therefore call for the case diary from the concerned police station. At this stage, the learned counsel prays for interim bail, drawing attention to order dated 28/11/25, passed by a coordinate bench of this court in BA 3742 of 2025. This was with regard to the same police case? No.
No, different police
Different
case.
police station.
In connection with Murajhar PS case number 235 of 2020. The para 3 and 4 of the said order may be reproduced herein. In that order, this coordinate bench of this court, while calling for the case diary, was pleased to grant interim bail to the petitioner therein, mainly on the ground that he was already in custody for 16 days, and that the main allegation against him was a social media post which read as follows. That the instant case, though some elaborate allegations have been made in the fire, but the immediate cause of lodging of the FIR is the social media post. Then the factual metrics are similar to the case in which the coordinate bench was pleased to pass that order of interim bail. Where is the grounds of arrest? Which is the page number?
Page 20, my lord.
The learned additional PP SH Pora objects to the grant while seeking the case there objects to grant of any interim protection at least. Stop. Page
20, my lord.
my attention has also been drawn to the grounds of arrest in which it has been stated inter alia that by his provocative post, the petitioner is trying to encourage separatist sentiment, semicolon, that his post has attempted to break down democratic process and mob violence, semicolon, that by his post, he has supported and abetted terrorist attack. Upon going through the post again, I find that in the subsequent post, clarifying and apologizing for the earlier post about asking why such incidents take place before elections, the petitioner has requested the administration to arrest the culprits involved in the Delhi incident, bomb blast incident, and ensure that they are given appropriate punishment. In the circumstances, therefore, I find the factual matrix as of now to be broadly similar to the one in which the order dated 28/11/2025 was passed by the coordinate bench. Accordingly, therefore, while awaiting for the case diary, perhaps the under trial detention of the petitioner who is in custody since 12th November 25 will be put on hold. Therefore, in view of the above discussion, it is directed that in the event 30,000 with 1 to the satisfaction of
Chief Judicial Magistrate Dorong Mongol.
concerned learned court CJM and subject to the following condition. He shall cooperate with the investigation and shall appear before the IO, making himself available for examination. He shall not hamper or tamper with witness. He shall not misuse his liberty to commit any illegal acts. And any acts detrimental to social harmony or prejudicial to the safety and security of the nation and society. Please the matter on next week.
Lordship, other matters, similar matters fixed on 6-1.
Similar matter is there.
Yeah, similar matter fixed on 6-1.
And same
Same day, Lord.
as such we are pressed for time.
Deeply
6-1.
honored.
6-1. I've recorded your objection.
Lordship.
6-1.
That is the law. May I please the lordship?
Please,
In this case, lordship, this
Typographical error, I don't know what the affidavit has been made by Priya Dhar or Priya Sarkar.
Swami also.
Kindly check the error pointed out by colleague on the bench. Priya Dhar, Priya Sarkar. There's some error.
Priya Dhar Sarkar, Lordship.
Priya Dhar Sarkar.
Yes, Lordship, she is the wife of the Indrajit Roy, Lordship.
Indrajit Roy. You should have written the same name as
Yes, Lordship, that has not been done.
Priya Dhar.
Yes, Lordship. Now, what has happened in this case, Lordship, this petitioner is a practicing doctor. He's having the certificate of the Bachelor of Indo-Allopathy System of Medicine. It's a BIA MS certificate, Lordship. It's from Kolkata that was issued. Now, the FIR has been lodged. I'm just referring to the FIR. Is at page number 14, Lordship.
Page 14.
Page 14, Lordship. By Dr. Abhijit Neo. He is the concerned person, he is the anti-quackery and vigilance officer, Assam. He lodged an FIR. And just page number 14, Lordship, the paragraph number, second paragraph. I would like to, Lordship, got it. I'd like to bring to your kind attention that one individual by the name Indrajit Roy is practicing as a medical practitioner at Maya Ayurveda situated at END colony under your jurisdiction. He attends his clinic and provides treatments to patients who believes him to be a qualified medical practitioner. This individual has mentioned that he is a BIMS graduate and displays the registration number such and such BIMS, which is not a registration number issued by the Assam Council of Medical Registration by the Assam State Council of Indian Medicine, Assam, to qualified doctors. But the particular registration number is from Kolkata Lordship. In the second paragraph, it has been mentioned, we had written to the registrar ASCIM in connection with the registration of Indrajit Roy as a BAMS practitioner through email on the 14th of September 2025. The registrar ASCIM by letter number such and such dated 19 September 2025 replied that the Indrajit Roy is not registered as a BAMS practitioner and the registration number such and such in bracket within bracket Lordship, the Kolkata is there, was not issued by the Assam State Council of Indian Medicine, evidence number 4. So this is the basic allegation, Lordship, that they have verified from Assam, Lordship, but the registration number is from Kolkata. Based on that particular thing, Lordship, the petitioner has been arrested. He is in custody for last 40 days, Lordship.
40 days.
40 days. 3rd of November, he has been arrested. And there is a clear violation of
Grounds
the...
of X.
Yes, Lordship. It is at reasons of arrest at page number 19, Lordship. On 2nd, the FIR was lodged, and 3rd, he has been arrested, Lordship. And the reasons of arrest is impersonation of a public servant doctor. The accused person was found falsely identifying himself as a qualified medical doctor without possessing any valid medical degree or registration from the Medical Council of India. This is not correct, Lordship, as per the contents of the FIR, Lordship, because they had verified from the Assam State Council, Lordship, not from the Medical Council of India. These act constitute impersonation of a professional
He is not
engagement.
registered in Assam, but he is
Exactly,
registered in West
Kolkata,
Bengal.
Lordship. It is specifically mentioned in
According to
the
you.
FIR also, Lordship, and they have verified from Assam, not from Kolkata.
Let us get the.
Lordship,
Lordship.
otherwise, the documents that come to Lordship, page 19, reason of arrest, number 1, Lordship. Impersonation of a public servant doctor. The accused person was found falsely identifying himself as a qualified medical doctor.
Without possessing any medical degree.
Any valid medical degree or registration from the Medical Council of India, Lordship,
Hmm.
not from Assam.
No, the FIR, what I'm submitting, Lordship. No, what I'm submitting is the FIR. In the FIR, they have verified from the State Council. They have not stated that from Medical Council. They have specifically mentioned, we had written letter to the registrar ASCIM, the Assam Council, State Council of Indian Medicine. They have not verified this Medical Council, what has been mentioned in the reasons for arrest. And why is the document? Even Lordship, kindly see the list of documents, page number 20, the enclosures. The arrest memo, inspection memo, medical enquiry report, notice under section 47, notice under section 48, and the checklist. Nothing is there. Wherefrom they have come to the conclusion with regard to that. It's a clear violation of the honest judgment, Lordship. They have to be 100% assurance should be get with regard to the fact that he is required to be arrested, Lordship.
No objecting at this point, because
But,
grounds are
the
very clear.
FIR has been lost by, an author, on behalf of the Office of the Registrar of Assam Council of Medicine.
Exactly,
They have
Yes,
to file a
Lordship.
responsible FIR, isn't it?
Yes,
Otherwise,
yes,
they
Lordship.
themselves will be in trouble, isn't
Yes.
it? So
Let
let
us
us,
call for
keep
case
the
diary.
case diary.
What
Yes.
date may be given, Lordship? Statutory period is 60 days, Lordship.
It's Monday, Tuesday, say at 16, latest.
16, Lordship.
We should keep.
Silchar, Lordship.
Scan copy.
If
may
the
be-
first half of the week remains busy, we can manage, but the later part, we should keep
Yes,
some
yes,
space.
16.
16. Call for
16.
the case diary of 16, Silchar PS case number 1091 of 2025. The petitioner was arrested on 3/11/2025
Lordship,
much.
scan copy, I think.
Not scan.
Not required, Lordship.
Case diary comes in original.
Yes.
16.
May I please, Your Lordship? My lord, this is regular bail application, my lord. I am behind the bar since 28 days, my lord. What happened, my lord? There is no owner at all, though the allegation is under second theft and cheating. Kindly for a moment, FIR is at page number 11, my lord. My lord, the relevant portion is at page number, my lord, 18, 18.
Just a minute.
Type copy is at page number 11, my lord. It will be legible. 11, 1. May I read, my lord?
Yes.
Today on 13/11/2025 at 6:45 p.m., an information was received from reliable source that one truck bearing registration number loaded with a huge numbers of Exide battery, inverter machines, etc., which has been loaded at Exide Industries Limited, Nijon Complex, Paschim Bahagapur campus on 12/11/2025 and was supposed to go to Silchar to deliver the aforesaid consignment to Exide Batteries Limited at Silchar. But the driver, handyman, and the owner of the aforesaid vehicle with a criminal conspiracy with their accomplices have hijacked the said vehicle along with the loaded items and escaped the said vehicle somewhere in the locality of Dodora area under Hazupias with an intention to steal the loaded item. But with an intention to steal the item, loaded items, and to sell it to someone, to some unknown miscreants for their wrongful gain. The information entered by OC Hazupias by Hazupias GD number such and entrusted IC Dodora OP to contact inquiry, and IC Dodora OP also entrusted me to contact inquiry by FF. In this regard, an inquiry has been caused and searched for vehicle number such at Dodora area, and the informed vehicle found at Dodora in front of petrol pump of Sofikur Rahman on parking. 3 persons found in the vehicle and accordingly apprehended them, who are the driver, handyman, and owner of the said vehicle, and illegal consignee, purchaser of the items in the locality of Singimari area under Dodora OP Hazu. During search, the vehicle assets the below mentioned items has been recovered. So, my lord, the vehicle along with all the alleged stolen items have already been recovered. So, further custody may not be required, my lord. So far, the page number 22, my lord. Forwarding report, my lord. Page number 22, my lord. The accused person of the FIR accused in the case, the hijacked truck vehicle number such and such have been recovered from the possession of the driver, handyman, and owner of the vehicle with loaded huge numbers of batteries, inverter machines, etc. So, well, there is no any owner at all. Nobody claimed that such and such articles, my such and such articles have been stolen by someone else. There should be owner, my lord. There should be claimant. Somebody to claim
No, it
that
was
my
loaded.
properties have been.
Anyway, when
Moi
when
to
can you get the
mane
diary?
intending
Hajo
mane purchaser.
Hajo PSK. When can you get?
My lord, I am the intending
CV
purchaser, my lord. I am neither the
required.
driver, handyman, or the
No.
owner, my lord.
No, not intending purchaser. As per the allegations, the truck was to go from Exide Industries to Silchar.
Yes.
To Silchar.
My lord, whether the Exide in the Industries Limited
No,
make any
Next week.
complaint, my lord, they have not filed any FIR, my lord.
That is also there.
My lord, due to some defect of the my lord vehicle, we take it to the garage for repairing, my lord. By this time, the police personnel lost this case, my lord. Informant is a police personnel, my lord.
Because the vehicle recovered from the possession of the petitioner.
No, it's interim will not be possible. Call for the case diary.
I am neither the driver, handyman, or owner.
Concerned from Hajo PS case number 478 of 2025. The accused person was arrested on 14/11/2025. This is the matter on 16th.
My lord,
16th.
I leave it.
May I, Mr. Lord, this anticipatory bail application FIR is on page 11.
Yes, FIR is a,
Page 11, may I read? With due respect, I beg to state that on for 24/4/2005 at about 5 p.m. when I was looking for my goat and reached in front of the accused house, then the above named accused person taking advantage of loneliness offers vulgar invitation to me. But when I realized his ill motive, then I tried to run away from the place. Then the accused person also chased after me and caught me by grabbing hair and threw me to the ground and started stuffing with me and destroyed my chastity. At that time, I started screaming loudly, but the accused person only to free me after completing his evil desire. Then I cried and woke up in the state of shock and found bleeding profusely. By that time, the accused person left this place. It is stated that the place was deserted and like a forest. It is also stated the accused person saying loudly that he killed my goat. After that, Lordship, the police has searched his house for goat, but nothing has been found. That is page 15.
diary has to be seen, that is still diary.
There it,
All for the allegations are.
Yes, Lordship.
Serious. Call for the case diary of Pathar Gandhi PS case number 101 of 2020. Under section 64 of the DNS. Please leave the matter on
Lordship on 8/1.
after
It's
the
anticipatory date.
Obliged.
Forwarded to application. Lordship, I am apprehending arrest in an unregistered FIR, Lordship. Lordship, on 21st of November, I received a call from one DJ Pegu, supposed to be a sub-inspector of Borborua Police Station, Dibrugarh. Lordship, I have annexed the call log, from which number he called me to my number. I have annexure 1, page 11.
Seen.
Lordship, then I inquired through a lawyer whether a FIR has been lodged or not. The lawyer, after making some inquiry, informed me that one lady, Chainika Borgohai, resident of Moranhat, has given a written complaint there in the PS
Against you.
against me. So, Lordship, I am apprehending that the FIR may be registered and I may be booked under section 69.
What kind of allegations? is-
Allegations are at page 5, Your Lordship,
Page 5.
page para 6, page 5. That Chainika Borthakur, that the information married to one press conference till then. Lordship, she has alleged in the FIR that I promised her to marry and thereafter I backed out. Lordship, facts of the case are that I had a live-in relationship with the prospective informant from 2023 to 2025. So in the meantime, I got a job, permanent job as a graduate teacher. So she came to know and to debar me from joining the job, which is supposedly, I have annexed the order of the appointment, Lordship, page 12, annexure 2.
Get the report.
Lordship.
Get the report. Wait, which police station?
Lordship, it's Borborua Police Station.
Dibrugarh.
Dibrugarh. Hemajit.
No, Borbora is, I think, Dibrugarh.
Dibrugarh, Lordship.
Dibrugarh. But it is Silapatra PS, Lordship, district.
Silap
Court.
Sarpir.
Yes. The cause title. Phase 2, Lordship.
Borbora police station, Dibrugarh. Silapatar. Where is
Lordship,
Silapatar?
actually, I also
Lordship, phase
came to
Phase 2,
procure the-
Lordship, in the cause title.
Yes.
It has been recorded as PS Silapatra District. Number.
0 FIR. In page 2.
On Lordship, I'm sorry, it's apprehending arrest in connection Borbura Police Station.
Borbora, it is Borbora.
Yes, I'm sorry.
At this stage, only a report will do.
Report from Borbura.
Lordship, till then, I may be protected.
No, Lordship, let the report.
Lordship may appreciate one order of our own Honorable High Court.
So I'm aware of this kind of orders. If your facts are,
Lordship,
the
my
facts, if your instructions are correct, then it may be
Lordship, my job
justified.
will be
That
at
it's a
stake,
relationship problem between two adults.
Yes.
My job will be at stake, Lordship. Moreover, Lordship, the lady is married. That I came to know later on. I have mentioned the name of her husband also.
Uh,
Lordship, page 5,
the
para 6, middle part, Sri Pranab Thakuria, She is married to Pranab Thakur. Yeah. There is no false,
That marriage is
Promise
not
of-
dissolved.
not dissolved, Lordship. So how can it be?
Heard invoking 482. The petitioner is seeking anticipatory bail. Oh, you have information about the
Yes, yes, Lordship.
about one FIR/complaint, Ezahar/complaint, dated 19/11/2025, lodged by one Srimati Sanika Borgohain before the Borboria police station in the district of Dibrugarh. It is submitted that however, the petitioner, however, does not have the copy of the Ezahar nor other details regarding the other details, apart from the fact that other details. Drawing attention to para 6 of the bail petition. It is contended that the petitioner and the informant were in a relationship since 2023 and subsequently. And in the meantime, he also got a job of assistant teacher. It is further contended that subsequently he came to know that she was already married to one person from 2013. And thereafter a dispute arose between them. It is submitted that in the backdrop of this relationship dispute, the complainant might have made some allegations against. Call for a report from the concerned police station regarding registration of police case on the basis of the said complaint dated 19/11/2020. Then we call for the case
Lordship, my
diary.
job will be at stake,
We
Lordship.
call for the case diary only. We can call for the case diary if case has been registered on the basis of any such
Status whether it is registered or not.
FIR. We can call for the case diary. The case diary of the same may be sent. Or in the alternative, if the investigation has not proceeded, then a report regarding the details of the matter.
Lordship, my verification is going on. My job will be at stake. I am annexed the order of my appointment, Lord.
This, it happened as a very inopportune time anyway. It is submitted that petitioner has recently got a job as assistant teacher. His service will be jeopardized in the event of his arrest and seek some interim protection. Upon giving my consideration to the matter and the said prayer, it is directed that in the interim till the report or his diary is received from the police station. No coercive measures like that.
Yes, Lord. Yes.
No coercive measure with regard to the said complaint shall be taken against the petition. List on
Lordship,
66171.
Lordship, CDR report is required also.
Alternative I've given, because if CD has been opened, then we might as well see the CD.
Lordship,
If not open, then how can he send the CD?
Yes.
So in that case, the IO he'll send
Your report.
yes.
6551 or 6 anything
6-1, Lordship.
61.
I am obliged, Lord.
Yes.
My lord, is a
Tell-
pre-arrest bill application. Page 8 is the FML. The petitioners are Nabo Mohanto and Parashmani Das. They were working under the store manager Dipankar Kolita. Their house has been searched, and my lord, on first 12, paragraph 10 and 11, I have stated, my lord, they have been on 1/12/25, they have asked for interrogation. They appeared and they have given the statement. On 4/12/25, they have given their statement. Their house has been seized, their vehicles has been searched and seized, And now, my lord, they have again been called on 13/12 to appear before. My lord, I will appear only thing because it's a non-bailable offense. And the seizure list I have given, my lord, page 15 onwards. 15, 14 is also.
Allegations are, these are, they are accused of fraud and manipulation.
Yes.
My lord, that is only.
Yes.
But one thing, my lord, I don't understand here, how the police, Supreme Court, a recent judgment has also said criminal conspiracy and, my lord, breach of trust and cheating cannot run simultaneously. Yeah, Justice B.V. Nagaratra has just now, few days back, has delivered.
They cannot be convicted together, but,
Together. Only thing, my
Sections
lord,
may be attributed.
Huh?
Sections may be attributed.
my lord, only thing that I make a statement, I have been going for the interrogation. First 12 and fourth 12, I have made my statements. I have been allowed to stay there for 32 hours. Para 4 and 5, para 10 and 11, I have made a statement, my lord. The CT will come and it will be produced before the court. It will be shown that I have made my statements. And my lord, 13/12, again, I have been asked to appear. Only thing, there is a non-bailable offense, my lord. And the search and seizure has been done. My vehicles, my mobile, even now I have got the information, my bank account has also been seized and stopped, man. The seizure list I have annexed and out, man. Page 13 onwards.
vehicle has been seized and
My vehicles has been seized, mobiles has been seized. Page 13, then page 14. Page 15.
otherwise these are serious matters.
Yes, Lordship. That's why CD will be required.
CD may become a lot, some protection. I am supporting the interrogation. my lord.
This is without granting it. Short it may be.
My lord, because my lord, everything, when I have made my statement,
Which police station?
But-
Boko.
It's from.
Can you get it on Friday?
Yes.
Can you get it on Friday?
Yes,
my lord,
Lordship.
because my lord, if the my lord, now interim is not given, Saturday I have to appear, this will become infructuous, my lord. If they arrest me on Thursday,
That's true.
Friday, Lordship.
my lord, Friday, if they cannot bring it, my lord. So, my lord, some protection may be given, I will appear, my lord. I have made a statement on oath.
Take care of it, Lordship.
My lord, I have made a
Take care
statement,
of it on.
No, suppose they,
I have made my
Otherwise,
statement
the
on oath.
Emotions are serious. Lord.
My lord, because their main allegation is against Dipankar Kolita, the store manager. He is, we are working under him, my lord. I am not Dipankar Kolita, my lord.
There, fire named accused persons. Lord.
yes, yes.
My lord, FIR named accused persons are always there, my lord. If I am arrested, my lord, then it will go, because my lord, para 10 and 11, I have made my statement. That 1/12/25 and 4/12/25, I have appeared and I have given their statement.
This can be more of breach of trust, actually.
Breach of trust, nothing more, my lord.
No, these are serious matters.
Yes.
This-
My lord, your lordship will,
Also
everything has been seized.
Third, Pierre Roy Chaudhary, who submits that the petitioners have earlier cooperated with the investigation and they have been examined by the police at length and several materials, including their phones and vehicles, have also been seized and therefore seeks interim protection with regard to the allegations. Full stop. The case arose, fall for the case diary of Boko PS case number 368 of 25. The so and so sections. The case arose out of an FIR dated so and so, dated 28/11/25, lodged on behalf of Brahmaputra Biochem Private Limited, where 3 persons are named in the FIR. And it is also alleged that they were working under the planning and guidance of one Dipankar Kolita, store manager. The primary allegation is that these persons working with regard to the way bridge of the firm had committed manipulation and tampering of records and weights and caused financial loss to the company. Let's stop. The learned counsel prays for interim protection. However, at this stage, only the diary may be called for. Leaves the matter on
On
Friday.
15, Lordship.
Friday.
15, Lordship.
But 13, if I am arrested,
Only
my lord,
one day
then
left,
No,
Lordship.
15, they have to appear on.
I have to appear on 13.
Lordship. On Friday.
My lord, then my lord, it may be remain on motion itself because it may not reach and my lord, I have to, my lord, then I have to, my lord, I have to face the consequence.
12, Lordship.
My lord, if the city doesn't come and it, my lord, some protection, my lord, then nothing will happen, my lord.
12, 12.
Because my lord, if ultimately it doesn't reach or something, CD doesn't come. Because I am, if something serious would have been there, I would have been arrested by this time, my lord.
It is submitted that the accused persons have been asked to appear again on 13th, 13/12/2025. And it's straight that till the returnable, they may be given some interim protection so that and they can appear. As otherwise, the petition may, if they're arrested, the petition might become infructuous. Then you call it on 17th.
Hmm.
The learned additional PP, however, objects to the ground of interim bail. Otherwise, actually, this out till 17th, you get it on 17th or 16th. 16th. Call for the case on 16th. Yeah, in 25,000 it on 17th, subject to the condition that they will cooperate. They will render further cooperation to the investigation and appear before the IO. The next day, appear to the IO for further examination. Shall not hamper or tamper with the evidence.
Obliged, my lord.
16th. Otherwise,
With
these
an
are,
observation, Lordship, if anything found against the petitioner, then interim may be.
and that is always there. That is always, because these are dishonesty oriented offenses, alleged offenses.
Obliged.
Dishonesty oriented offenses, the approach should be strict. Because there is
Obliged, my lord.
My lord, it's also bail is a actually cancellation of bail, my lord.
cancellation.
Cancellation of bail, my lord.
Oh, you have mentioned.
Yes, somebody, yes, you want to file a response, my lord.
Your further response.
I'm for the accusers.
Bail was granted in
Yes, bail was granted.
additional session. What is the impugn order?
Impugn order, your lordship.
Page
will
57,
get- Yes, 57.
Originally, bail was rejected by this honorable court, anticipatory bail. Then, my lord, it was rejected by the honorable apex court, my lord. Thereafter, they file a application before the my lord learned trial court.
Hmm.
And trial court granted bail on medical grounds. But so far, there are two petitioners, my lord. They are husband and wife. They are, my lord. They are earlier also arrested in a different case, my lord, because this type of fraud. They have in the same land. They have given to my lord, taking the loan in different bank. Here also, my lord, 3.6 crore loan has been taken. So, my lord, same land, my lord, sell out to some other person in 2017 and giving mortgage to my lord in 2021, by giving a certificate and non-increment certificate, producing that they have taken the loan. So that's why, and the loan is also not repaid, my lord. Then this FIR was lost, my lord. So all along case was, my lord, that is, my lord, rule of law, at least, my lord, learned trial court granted bail, but they should have approached this honorable court, my lord, because this honorable court first, my lord, rejected the bail. But anyway, my lord, let them
But
file.
apex court also rejected.
Yes, also
Rejected
rejected.
and after disclosing all the facts on medical ground, they have renewed their pair.
All right,
I-
husband was granted on the medical count. Why the wife? Wife was not a my lord, single allegation, a single finding.
Then if the apex court had rejected, then you cannot go. Can you go directly to the apex court?
No, on lordship, depending on medical ground. Lordship.
Or no, I'm asking, can you go directly to the apex court for bail? You can perhaps, but usually only on appeal.
Exactly, my lord.
Usually only on appeal. SLP. Only on appeal. Directly, you have to make out a case of violation of fundamental rights. Then you can perhaps. So seeking cancellation of. So what is this is the impugn order,
My lord.
you know. And your party he was the informant.
My lord, I am the informant, my lord. Because we are not getting money, my lord, because the mortgage which was given, my lord, already sold out to the another man. They have sold. Then, no, let them file response, my lord. I am not that.
No, they have really different.
Because my
So-
submission that rule of law should have been, my lord, followed.
It's true.
Because
He has referred, but I don't know. Usually, I would have left it to the invoking section 483(3) PNSS, the petitioner herein was the informant of, what is the PS case? Paltan Bazar PS case number 40 of 2025
My lord,
is agreed by order dated 18/6/2025, passed by the learned additional session judge number 5 in AB number 129 of 2025, whereby bail was granted to the respondent number 2 on held grounds. The petitioner, the applicant herein is seeking cancellation of the said bail, contending that earlier the bail was rejected by this court and thereafter even by the Honorable Apex. Here, Mohanto Learned Senior Counsel, and assisted by A. Ahmed and R.J. Bora, Learned Additional People.
Well, I have one comment.
Yeah.
That it is, my lord, the application for constitutional bail.
Mhm.
Now it has been registered as a BAML.
my lord, that is done by the registry. I have not done it.
No, but the question is that, my lord, it cannot be a bail application.
It cannot be a bail application. It
My lord,
it would be a I.
no, I,
Sure, maybe,
my lord, let me submit, my lord. I have filed a bail application within bracket IA.
Hmm.
Then registry corrected now, my lord, BA. They have corrected. I have not done it. Now in the 1st of December of this year, there is a notification published, my lord. Just now I have received, my lord.
Yes, yes.
And
I
in
remember.
pursuance to that receive application, my lord,
Bail within bracket cancellation.
the bail within bracket cancellation. That is the main concern, my lord, from 1st of December, my lord.
I have filed.
So the registry can well done it, my lord, because we cannot pass it now,
Can we give a direction to
my lord. As per
rename
the
it?
notification dated, my lord, 1st of December 2025.
rename and re-register as BA cancellation?
BA cancellation.
Cancellation. এখন পাইছো নি তই?
That makes it clear.
Right.
That is always better,
Ah.
because IA has different categories.
কিন্তু যদি objection level বস্তু নহয়, registry বস্তু।
The petitioner side shall furnish copies to the prosecution as well as to the private respondent. This pointed out that the correct nomenclature for this proceeding should be BA within bracket cancellation as per the notification dated
1st of
112.
1/12/2025 issued by this court, the administrative side. The registry shall do the needful regarding the same. Copy of this order may be placed before the registry. And you,
Take some time to learn.
after vacation,
My lord,
this is the matter, you should be, you can suggest a date.
not
Mutual,
8 and 9. January 8 and 9 by immediate, my lord. Not 8 and 9, not,
then it has to be in the first 3 days or after view.
my lord.
After
Immediately
My lord,
19 or 21.
my lord, no problem.
19,
Develop.
19/1.
This is your lordship certificate case. Petitioners are behind bar for 1 year, 7 months, 4 days, your lordship. POXO, allegation under POXO, your lordship. There are altogether 17 witnesses. Out of these, 7 witnesses were examined, your lordship, including the victims. But however, one aspect I just want to point out, your lordship. Victims are not represented, your lordship, although they are parties. Probably your lordship will have to
That
engage.
Service report, my lord, we have not received, my lord. We have again, my
Yesterday,
lord,
this is the
Same, these
yesterday,
two persons.
other matter.
Adam.
my lord, we have, my lord,
Here also we have taken the grounded grounds of arrest were not furnished to us.
let the service be received, report be received, my lord. Otherwise, my lord,
Yeah.
case of
can-
POXO, my lord,
I'll let the third done. Is important. To submit that one of the contentions taken in this bail petition is that is non-compliance with the statutory notices at the time of arrest of the petitioner. Scan record is available. However, service upon the informant
50 out
is
of
awaited
50A.
as penal provision of POXO is involved, therefore the service is necessary. You take instructions,
yes, my lord,
then
we
with
take.
appoint an amicus.
Lord,
The
Let
prosecutor,
the, my lord, instruction be received, my lord. Otherwise, my lord,
yes,
If it is received, then my lord, they may also appoint directly, my lord.
They may also,
Yes.
first that option has to
Yes,
be,
my-
right? The learned prosecution shall take instructions regarding service of notice upon. Leaves the matter on.
Next week, your lordship, if it is not inconvenient.
18, my lord, 18.
Obliged.
Last 2 days, we should, let us keep some space.
My lord.
Let 16, 17, 15 be, jam. To be easier to manage. 18, 19, we should keep space for new matters.
Right.
Otherwise, because
Then, my
all
lord,
of
the
you have
first
to
week of-
get the orders
first
also, it
week
has
of-
to be uploaded also, right?
The first week of January, but immediately after reopening.
It will be on 18th
Yes, my lord. 7 or 8,
Right.
my lord.
or make it 17th.
17, your lordship.
Or you think it may not come?
17
No,
January.
the instruction of notice,
Only for
instruction,
Only
18,
for instruction.
18.
lordship. Deeply obliged.
May I, your lordship? This is a regular application lordship. Road accident case lordship. My lord, this is behind our last 37 days lordship. Page 14 is the affair lordship. Petitioner is the, my lord, 56 years old professional driver lordship. And when he saw the person lying on the road, he went to the Thalamara police station and to inform that the Thalamara police station lordship. Thereafter he was arrested, my lord. Purely a road accident case lordships. And petitioner did not do that lordship. It is hit by some other vehicle. Thereafter he was arrested when he went to inform the police station lordship. This 14 is the affair.
If that is true, then very unfortunate. Who will help accident victim? Is it
Accident, my lord, my lord, then question is that, my lord, after the accident, my lord, he has not stopped there, my lord. Although, my lord, it is not safe for him also.
No, no.
But if the question is that, my
No,
lord,
that provision is under whole, right?
yes, yes, that is all.
Truck driver.
Yes,
The strike was there.
yes, that is all.
That
But, my lord, in this case, my lord,
that holded provision, this one.
no,
that is
this
true.
is, my lord, this register under section, my lord, 105, my lord, yes, 105.
It's road accident case. When he went to the Thalamara
No,
police.
he has not went, my lord. He fled away, my lord. Then, my lord, next police station, my lord.
Yes,
The nearest Thalamara police station apprehended that truck, my lord.
I have to go to the
Thereafter-
station lordship. Otherwise, I will be, my lord, hit by the person's lordships. Assaulted by the person's lordship. 56 years old, my lord, driver lordships. And 37 days behind the
Case
bar.
diary has come.
Case diary has come, my lord. Case diary come along with a postmortem report, my lord. And cause of death is, my lord, head injury, my lord.
Oh, it was prima facie investigation says that his vehicle hit the victim.
Yes, my lord. Even the driver also said that, my lord. The victim, my lord, he came, my lord, the backside of the back wheel of the truck, my lord, hit at the victim bicycle, or he was walking there, my lord, he hit it and then he fell down, my lord. But there is no such eyewitness, my lord, who has witnessed my lord, incident.
37 days lordships. And 56 years old driver lordships. And he's a local people lordship. Kindly allow on any condition lordships.
105, right?
Lordship.
105.
Malak, he went to the nearest police station
304.
to inform the police lordships.
106 subsection 2 is under hold. Mr. Borwa, 106 subsection 2 is under hold. That whoever causes death by rash and negligent driving
Yes, that is
and
under
escapes without reporting shall be punished with imprisonment
105 is, my lord, still, my lord,
under hold.
no, 105 is, my lord, it's still in
It's a
operation.
different- It is
106,
4
Yes.
yes, my lord,
earlier.
304.
I know earlier it was a available section lordship. My lord,
No, it continues to be available. This
Yes,
causing death by rash and negligent act. But now some changes have been brought about.
lordship. Kindly consider our length of detention lordship. 37 days lordship. 56-year-old, my lord, driver lordship.
No,
On any condition lordship.
heard so and so
Lordship.
invoking 483, the petitioner, the accused, Mohammed Sirajul, seeking regular bail in connection with Tezpur PS case number 719 of 25 under section, so BNS. He was arrested on 3/11/25. Full stop. The gist of the allegations in the FIR dated 3/11/25 is that one person was found on the road with severe injuries and was and was dead, and subsequently the petitioner driving his vehicle AS01 LC 9178 went to the nearest police station and he was apprehended as he himself went to the police
Actually,
station.
Lordship, as per
Is
Mr.
that mentioned in the FIR?
Lord-
I should not.
No, that is not Lordship.
That's not mentioned. Where is the FIR?
Well, my lord, page 14,
Legible from you?
page 14, Lordship.
Full stop. Next. Who was dead? Full stop. It was alleged that the petitioner driving his vehicle so and so was the death of the said person in that driving his vehicle attempted to flee without informing the police after causing the accident, and therefore he was apprehended. Full stop. The case diary has been received. Full stop. It is submitted by prosecution that so far investigation has not found our eyewitnesses, and it appears to be a case of prima facie accident or
Accident,
ma-
Madam.
the materials indicate so far are indicative of the incident being an accident rather than murder. Accident, just like that. No need to write. Progress is there. There's
Progress
reasonable
is there,
progress in the investigation in the given circumstances, allowing this bail petition, that he's allowed to go on bail of 25,000 at 1/0 to the satisfaction of the concerned learned court, CJM Tezpur, right?
Sunitpur Tezpur, Lordship.
Sunitpur Tezpur, and subject to the condition that he shall not abscond, and he shall not hamper or tamper with evidence. Bail petition stands allowed and disposed of. Return case there.
I am deep blood.
Yes, please. Lordship, this is regular bail application, Lordship. The accused is behind ever since last 52 days, Lordship. And basically the allegation is, Lordship, section 9 and 11 of Child Marriage Act. So Lordship will find the affair in page number 6.
POCSO not given, right?
POCSO not there, Lordship. Victim has already been recovered. Now she is with her parents.
Madam, in this case, search is submitted, Madam.
In heard so and so, invoking 483, the petitioner is seeking, Rahul Pacha is here seeking regular bail in connection with Kayan PS case number 51 of 2025 under so and so section. So he was arrested on 19/10/2025. The learned counsel submits that the victim, the alleged victim girl, who was allegedly subject to a child marriage, has been recovered. The same is also mentioned in the forwarding report. I think.
Yes, in affair itself mentioned here. In last portion, Lordship. It's affair.
ছোৱালীজনীক উদ্ধাৰ কৰি
Yes. This is an affair also in 2024 December. Lord.
no, DSN. Must have been recovered. I'm just trying to confirm. Can you help me?
Yes, Lordship. But I have stated in my petition, Lordship.
It is not clear from the apparent forwarding, my lord,
Must
whether
have-
victim has recovered or not, my lord.
The victim are with their parents, Lordship.
Paragraph.
Lordship,
If you have stated in the paragraph, I will refer to that. Para 4.
yes, sir. Yes.
Drawing attention to para 4 of the petition. Submitted that
May I allow 1 minute? Subsequently,
they who later came and took custody. That
later on, I
The
came
pa-
back
the
to the
petitioner-
custody of the victim.
the petitioner, the alleged victim girl is now with the informant. Who is our father? Informant is our
With the
father,
parents, father and mother.
the informant. Was handed over to the informant. Learned prosecution submits that the case has, in the meantime, upon completion of investigation, the case has been charged sheet.
I charted number, my lord, 223/2025, dated 30/10/2025.
Considering the completion of investigation and length of detention dash, the accused herein is hereby allowed to go on bail of rupees 30,000 with one security, subject to the condition that he shall cooperate, he shall not hamper or tamper with evidence. Uh, he shall be available for trial upon commences. He shall not commit any illegal activities.
My objection may be recorded, my lord, since it is a search that case,
The learned additional PP objects to grant of bail at this stage.
my lord.
Highly object.
Short break.
My lord. ठीक है, सुन लो। ठीक है, रेखा तो पूरी लो। ठीक है, तो मैं जो
May it please your lordship. It's an unfortunate incident. The petitioner before your lordship is a lady who is aged about around 40 years, married, has a husband who works in the Indian Air Force and has also a son, my lord, who is also a practicing advocate of this court. Through Facebook, my lord, she became acquainted with a boy who is aged about 29 years of age. He earlier had a divorce from his marriage, and here was some sorts of his emotional dislike for women and all because of his earlier broke up relationship. Ultimately, my lord, he could not hold it and he took the extreme step of taking his own life. Now, after many days, the family boy. He could not handle the depression, took his own life. This petitioner has never physically met the boy ever. She lives in Jorhat, the boy lives in Guwahati, and it was inside his grocery shop he committed suicide. Now, she is in custody, my lord, from, just a moment, from 21, just a moment, 23, 2025. But custodial intervention may not be necessary at this stage. She is in judicial custody. My lord, other than the merit or the necessity of custodial detention, at the very initial stage, my lord, the police committed some mistake, which are constitutional mandates of that reasons of arrest, grounds of arrest, and all those things. My lord, the lady was picked up from her house on 22/11/2025 at in the morning at around 6:30 to 7.
Right.
And probably that the diary will reveal whether they have made the entry of picking up the lady from Jorhat. Since it is morning and not sunset, so
Yes.
so that they don't need to require to take the magistrate order. But since it is more than 24 hours which had elapsed after her production, they ought to have taken a transit remand. She was brought to Guwahati and produced before the magistrate on the next day in the during the holiday court in the court of the magistrate at almost 3 o'clock in the afternoon. Your Honor, your lordship will kindly see the arrest memo at page 31.
Yeah.
Now your lordship will find this is the arrest memo. Date and time of arrest on 23/11/2025 at 11 a.m. They have shown the arrest at 23/11/2025 at 11 a.m. Normally, my lord, when we speak about the date of arrest, for earlier for 167(2) and under the new sections of BNSS, for this calculation of the statutory period, we calculate from the date of the forwarding report, for the period of 60 days or 70 days. But when we talk about 24 hours constitutional mandate, it has to be from the time when she was picked up. And in this case, that 24 hours has first elapsed. That is my first ground. Second, your lordship will find that column number 4, name and particulars of relative present at the time of arrest. That has been left blank. At page 31, your lordship will find name and particulars of relative present at the time of arrest is blank. Then signature of relative friend is also blank. Now your lordship will see the grounds of arrest. You are FIR name accused of the case. As per CDNS, it can say that you have several times contacted the victim of the case. Statement of intentness clearly establishes your involvement in the commission of the offense. These are the reasons. I leave it to your lordship's discussion whether this can be the reasons and the grounds of.
Mere telephonic communication cannot be.
And she had never physically met the boy, my lord. And you'll also see that these are the statutory mandate. I need not repeat all those things. That you, even if the family members are not there, you have to give it to the relative, neighbors, and you have to get the attestation of those signature which have been described. Now you'll also look at that page, the next page at page 32.
Page 30.
Next page, madam.
Mhm.
Here the signature, this is given under section 47 of the BNS. And this next page is page 33 is the WT message. And I have given the medical certificates from page 34 and all. So my respectful submission is that so far this case is concerned, other than its non-compliance of the constitutional mandate of 24 hours and the not informing the relative, friend or the family members, and coupled with the fact, my lord, that she has been fully interrogated, taken to 2 days police custody, interrogated, now is in judicial custody. I respectfully submit that further custodial detention of this accused petitioner at this stage may not be necessary because she has no sons of esconder. Her husband is a Indian Air Force officer at Jorhat. Son is also is well established. So I respectfully pray that your lordship may kindly consider for bail at this stage, my lord. I don't know what the case diary will reveal.
The FIR was lodged by the elder brother of the.
elder brother of the my lord, deceased my lord, and my lord, the previous night, my lord, the victim, my lord, victim, he was in talking terms with the my lord, this accused person, my lord, and they have a friendly relationship.
They were
But
in
after
relationship.
that, my lord, after that, she has not even her statement also recorded, my lord. After that, my lord, when they were talking, my lord, they suddenly disconnected her phone. She suddenly disconnected her phone, my lord. After that, my lord, she tried to, my lord, again call her back, my lord. Then, my lord, she has found the, my lord, found her this victim's mobile phone switch off, my lord. Thereafter, she has given us some post, my lord, that I have found this person's mobile has been switched off. So kindly see, my lord. Thereafter, my lord, the family members have inquired, my lord, and found that, my lord, this person was hanging, my lord. So, my lord, it's a case of, my lord, suicide, my lord. Only the parties there where the abatement parties they are, because it is the, my lord, victim, my lord, and the, my lord, the deceased, my lord. Sorry, the victim and the accused petitioner, my lord. They had some talking terms with the, my lord, although over telephone, mobile phone, my lord. But there are some relationship between them.
It was an like.
My lord, what has happened? I'll just add. I'll just
concern, my lord, these are duly served, my lord.
my lord.
It is a case
My lord, what has fallen from my
He was
lord?
arrested on.
Arrested on my lord 23/11/2025.
And my lord,
Apprehended on 22.
final cause of death is yet to ascertain, my lord, because the
No, I have
report is
never
not
come.
received, my lord, till now.
Well, what has happened when I was talking with him, with the boy was under depression. I could make out. He suddenly disconnected. I frantically tried because I am senior to him. I frantically tried to call him. When he did not pick up the phone, out of concern, I even given a Facebook post to go and ask the friends which are common to us that go and see. That shows my intentions that that I cannot be the perpetrator of the crime, my lord. It's unfortunate that the boy has died, but my respectful submission that at this stage, further custodial detention of this lady may not be required for so far the investigation of the case is concerned.
My humble
They
submission,
can later collect the electronic evidence, the CDR, call details, everything, they can do it. But that my custodial detention is not required.
my humble submission, my lord, investigation is yet to complete, my lord. On the
Heard learned senior counsel. Najee Bora learned additional people. Invoking 483 BNSS, the petitioners were seeking regular bail in connection with Borsuk PS case number 311 of 2025. And the 108 BNS. Fire dated 16/11/2025. It's lodged for the Borsuk police station by one Biswajit Kolit with the allegation that his elder brother died under mysterious circumstances in his grocery shop on 28/9/20. And that prior to his death, he had informed his mother and elder sister that the present petitioner was blackmailing and harassing him. And therefore, the family suspects her involvement in the death. The present petitioner was arrested in Jorhat on 23/11/2025. Full stop. Full stop. The learned senior counsel contends that the petitioner is no way involved in the alleged offense of abetting the supposed suicidal death of the petitioner, of the deceased, semicolon, that though she was picked up from Jorhat, but the statutory period of 24 hours before of production before magistrate was violated by the time she was produced before the learned magistrate judicial JMFC at Guwahati. Full stop. It is also contended that there is the notices under 47 and 48 are also deficient, and further contending that the notice under 48 BNSS, there is no reference to any relative or any signature thereof of the relative who was informed. However, the learned senior counsel has drawn my attention to a WT message sent by the police to inform some relatives. The case diary has been received. Learned additional PP submits that just prior to the death, there was communication between the deceased and the petitioner, and that the materials indicate that they were on friendly terms. And thereafter, when his mobile was found to be switched off,
That's after talking
petition-
to her, my lord.
Huh?
That's after talking to this petitioner.
just after the last conversation, the petitioner gave a social media post regarding the same, and for family members to inquire. The same is also contended by the petitioner, learned senior counsel for the petition. The whether as to whether the ingredients of abatement to suicide would come as a matter of complete investigation and more specially trial if one commences. Nevertheless, in the given circumstances, I am the considered view that petitioner should be granted bail. This is accordingly, he is allowed to go on bail of rupees 30,000 with once every life, particular condition that she
CGM Kamrup Metro at Guwahati.
shall cooperate with remaining investigation, shall not hamper or temporary. And that's all. CGM Kamrup Metro.
We are obliged.
Some of these cases, actually police, because we know, this abatement to suicide, that how that law is evolving, right? A linkage, all these things, and many, unfortunately, many such incidents to take place. So the approach should be, this is actually easier said than done. The approach should be of the police initially should be to investigate without arresting. Arrest should be made only when it is absolutely
Because, my
necessary.
lord, because, my lord,
That should be the approach everywhere.
it is the last
Especially-
call, my lord. It is the last call, my lord, with the, my lord, petitioner and the, my lord, victim, my lord. That is why, my lord, the proximate cause of death might be, my lord,
Yes.
before
But
there is.
if friendly
They
relationship
cannot
is found, if conversations are found at a
Now,
person,
what
then
they have-
examine,
What they have talked, my lord, that nobody knows,
Yes.
my lord.
person can be examined, and without arresting also person can be examined. The statements can be recorded. Because we really have to reduce the incidence of unnecessary arrest. Because this is the march of liberty. Of course, societal interests have to be balanced, but this is the path on which Honorable Apex Court is trying to take the criminal justice system, because
My lord,
the
in the FIR, my lord, she has
Malay,
been named, my lord.
Yes.
FIR
FIR allegations can be it's not an encyclopedia. Sometimes
No, my
it's
lord.
vague,
It- there is
sometimes
a-
incomplete, sometimes exaggerated. So the police has to go beyond that.
Abatement to suicide, your lordship, normally Supreme Court nowadays takes into the plea
No,
when
it's
it is
very
a case of dowry death
It's very
normally.
difficult to prove.
Yes,
because in case of married women, the presumption under 113A comes.
yes,
But otherwise, because abatement is abating someone to commit suicide is like that,
yes.
abatement within the meaning of 106.
Even the,
100,
Yes,
106.
yes.
Instigation, aid, conspiracy.
But
And
in the
even
FIR, my
she-
lord, there is a word, my lord, blackmailing, my lord. That is why,
Yes, yeah, that's true. But whatever it is,
what kind of blackmail, my lord, that is, my lord, trial will.
what
prove.
I'm trying to impress upon is that, see, the thing is that no, there should not be arrest at drop of a hat. So it should be after proper.
and here, my lord, the husband was a Air Force officer. There was no sons of abscondent. She would have cooperated with the trial. But what has happened, I can't undo it. But we are grateful to your lordship. We are obliged for your lordship's observation.
No, no.
These
sir,
these are the things which people, the investigating
the
officers can
family
learn.
is of course very aggrieved, you know.
Yes.
Suicide is a tremendous human tragedy. Tremendous.
My lord, I know the pain of losing a sister.
I know.
That's why I know the pain.
I'm aware of it.
Yes, we are obliged.
Pray for our soul. For our soul. Always.
May I please, your lordship, for your application, lordship, beyond the assume that 21 days, lordship, is shown as in this case and the main case is already released on by the coordinate business of this honorable court, lordship. There is two FIRs less in the form for the said incident, lordship. What happened in this case, lordship? There is a birth anniversary of late Jubin Garg was organized in Lakhimpur, lordship. And on the date, lordship, petitioner was present in the said organization, lordship. And under your influence, lordship, he due to sorrowful and remembrance of the late Jubin Garg, lordship, he is alcohol and under influence, lordship. And when he came out from the state organization, lordship, and then the brother of the petitioner, informant, lordship, he is also under influence, lordship. He puts him and as a heat of movement, some altercation took place. The director of the brother of the informant. Now kindly see the page. FR is the page 9, lordship.
Shikha Sharma is the sister.
Sister
of her brother who died.
her brother assaulted. Now in the same for the said incident, lordship, 2 FIR laws and the same first FIR, lordship, on the same date, the coordinator of this honorable court already released on bail, lordship. The petitioner is under influence, lordship. The informant brother also under influence, lordship. This is a FIR also.
There was a function, right?
Function, lordship. Late Jubin Garg birth anniversary, lordship.
Diary.
Yes, my lord. We have received the case diary, my lord. My lord, there are sufficient materials, my lord, because there are some eyewitnesses who saw, my lord, because he assaulted the victim, my lord, from in the head, my lord, from that side, my lord. So this is the vital part of the body, my lord.
It is true that
Let me complete. Now, my lord, the medical report is yet to receive, my lord. We have pray, my lord, let the medical report come, my lord.
lordship, medical
Because, my lord, there are witnesses who was implicated, my lord, and the injury sustained in the vital part of the body, my lord.
the informant brother also under alcohol, lordship, and he out of heat movement, lordship.
Who was what is this order of Amulya Sakya?
Amulya Sakya, this is a first FIR loss by the police of the said North Lakhimpur police. And the said
What is this?
this was here is clearly written state there and the medical report of the Amulya Sakya, brother of the informant. There is a physical assault at informant in front of court at 2 p.m. Patient is under the influence of alcohol. As a brother of the informant, lordship, he is under influence of alcohol.
Just a minute. Just give me. Read it again. The narration in the FIR is different, right?
Although
It's slightly
the
different.
incident is same, lordship, but narration FIR is different.
Let the medical report come, my lord, because
Lordship,
I has also, my lord, has paid in my lord,
petition
medical report
already
is yet to collect.
and main case already granted bail on motion days, first date of motion day, lordship. And petition also some health related issue, lordship.
The
Is
case
a-
has been, my lord, registered under section 109 of BNS.
Already 21 days, lordship. And due to under influence of alcohol, lordship, there is an altercation took place between them, lordship. I am admitted, lordship.
21 days to under
That's
14 days.
okay.
Only 14 days to them. my lord.
21 days he is arrested in main case and now he is shown arrested in this case 27, lordship.
Yeah, this case is slightly different, I think. This case is the same case.
Same case, two different PS, lordship, but incident on the same incident,
the
let
same
Jubin Garg
incident?
incident.
Different PS.
Look.
It's 390. 390.
On the same date, he was arrested
That's what this
in incident in
Allegations here is that that when he went to the market, suddenly he
Yes.
assaulted from the backside.
like
Backside. And then he died.
Thereafter, police came.
Medical
and-
report, when can we get it?
My lord, medical report, my lord, we are fixing on the short date, my lord, next week, my lord, on 18th, my lord.
18, Lordship,
Last 2 days, I'm keeping it.
Lordship,
with you,
15, Lordship, kindly, Lordship.
16 or 17?
17,
16.
17.
17, I have
16 Lordship.
a lot of cases already, not lot, few cases, but I do not know the number. 17, if it's okay for you, it's
17, my lord.
kindly take back this. The case diary has been received,
Yes, my lord.
but the learned additional PP, Mr. Borua, submit the medical report is necessary and shall be called for, maybe procured before disposing of this material. The petitioner was shown arrested in this case on 27/11/2020 in connection with North Lakhimpur PS case number 394 of 25. Arising out of an FIR dated 19/11/2025. Full stop. Lodged by the brother of the deceased.
Disease, not disease, Lordship, injured.
Injured, my lord.
Injured.
Sorry, brother of the injured. Oh, it's a 307. 307.
108.
1099, my lord.
I see. Brother of the alleged victim.
No, sister, he is a information sister of the injured purpose.
No, the victim, I'm mentioning about the victim. Sentenced to 41.
There is a
Lost by
Shikha Sharma.
one Sikha Sharma was the sister of the victim, alleged victim. Sister of the alleged victim. While retaining the case diary, call for the, you'll retain the case diary?
My lord, we retain.
While retaining the case diary, call for the medical report expeditiously. List the matter on 17.
17 to 1. 17, 12.
Masudi.
You can take this back.
Lordship.
Lordship, I kindly pass it over for the timing.
And
51 and 52 as well.
same.
May I please, your lordship. On the last occasion, CD and postmortem report and FSL report was called for lordship.
Okay, is there a not yet received, my lord, in this case?
I'm on interim lordship.
Lord, in this case. In this case, search sheet submitted, my lord.
But the CD has been pending for a long time. There's an observation also. There's an observation also.
Scan copy was called for, my lord. Scan copy of TCR and CD.
And originally CD was called for. Subsequently, perhaps.
Yes, subsequently after filing of the search sheet, my lord. Scan copy.
What was the allegation? What are the sections? Otherwise, we'll make it,
376, my lord.
make it absolute.
This is section number 103 and 3 of 5 BNS 2023 lordship.
Oh, that is
103.
Location one.
last year.
Item number Mojibur Rahman.
No, no, John Taku,
27.
27.
Sorry, my lord.
Beaten by his own son.
Yes, lordship. Lordship, I'm the friend of the son lordship. I was just walking in the park, Lordship, then I saw the incident, Lordship. Later on, I got to know about the incident that he died for heart attack, Lordship. I'm on interim, Lordship. I appeared also, Lordship.
Elder son.
Sorry, my lord, in this case, my lord, file, actually, my lord, office has provided a wrong file, my lord. This is not the
My
file of.
punching my husband in front of me. And there's allegation in the FIR against you also. And you also. Anyway, but this CD has been pending for a long time.
Last sons may be allowed, my dear lordship.
Since
I have cooperated, Lordship. I have appeared before the IO also, Lordship, on 9/5/25, Lordship.
no, it was received once, then it was sent back for up-to-date CSL.
Yes, Lordship,
FSL.
Lordship.
That was the thing.
And FSL
Thereafter,
report
it has
was
not come.
Yes, sir.
Thereafter, law may so many dates. There's an observation also. Anyway, what to do? What do you suggest? Wrong file has been given to me.
Yes, your lordship may fix it at 2, my lord. I will have to check from my office.
No problem. Otherwise, check it. Otherwise, we'll fix it another.
Obliged, Lordship.
If we fix it another day, we'll extend the interview.
Yes.
28.
PNS bail application, my lord.
The 28 also, my lord, CD not received, my lord. Petitioner is in interim. my lord.
Do you know when the CD was first called? 22-1.
22 yes.
So we have to be careful on this.
Yes, my lord, on 27 and
Because as you
28,
know-
my lord, I looked into the both the cases, my lord.
Many things can be a for.
Yes.
Obviously, that's crime is a vested interest. And it's alleged crime. Way back, because by now we have our own accountability.
Yes.
4 weeks, we have to dispose of regular bail application.
Yes. Your lordship may pay any date next week, my lord, I will get it, my lord.
The case diary is not received. The petitioner was granted interim bail on 13/12/2024 itself. And the case diary was called on 22/1/2025. Order dated 4/2 days, mentioned that the case diary be returned.
Lordship may kindly fix it on 18/12, my lord. This time I will get it, my lord.
That's not, numerous dates have passed, numerous dates have passed since then. And case diary is still awaited. Still. The case diary, the IO is directed to send the case diary positively on next day. Number two, the IO shall also submit a written explanation before this court as to why the case diary has not been produced despite the elapse of so many dates. Full stop. Is the matter on
18/12.
Interim order may be continued, my lord. Interim order may be continued.
Interim has to be continued.
My lord.
Interim order, passed. It looks bad for us also, isn't it?
Yes.
No, for the court also it looks bad. Interim order dated 13/12/2024 shall stand extended till the next date of listing.
Obliged.
Therefore, I said, na, at the time of mentioning, it is risky sometimes without going into the file.
Yes.
Extending, mentioning without CD.
29.
Also, my lord, up to date case diary.
On issue, if I am seeking a detailed report, some which will require investigation, and then of course, someone is very busy, so he may get delayed. But CD, all you have to do is
Yes.
pack it and send it.
Yes.
And bail objection, written bail objection is not essential. The prosecutor can always peruse. He's a
Yes.
trained person in law. He'll
Yes.
read the CD and if necessary, he'll object.
Yes.
Prosecution is also independent. The IO cannot direct the prosecutor. The principal.
I'm in interim.
Yes,
Here also petitioner is in time, my lord. Earlier CD was available, sent back for update.
yes, you were sent. Get it. The case diary was earlier received, but it was returned back as it was without the medical report. However, it has not yet been received today. Issue reminder for the case diary as well as along with the medical report. The interim bail granted by the order dated 28/7/25 stands extended till the next date of listing.
Interim may continue.
Extend next date of listing. Stop. When should we?
6-1, man.
Yeah. After 6/1. 6/1.
32, my lord, charge sheet submitted in this case.
Lordship, earlier interim was there, Lord.
Yes, I've seen. Last order also it is by a coordinate bench. So the scan record has come. Is he sent up for trial? He's also sent up for trial.
Yes.
I think you have mentioned.
Yes.
Lordship, only inquiry for his name is in the charge sheet or not? That is the.
As per your instruction, he has been sent up for trial. He has been sent up.
My lord, only.
Deep Jyoti Soikyan.
Yes, the present petition.
Only regarding my lord, charge sheet, my lord, it has been mentioned.
Yes, yes.
32, my lord, in item number 32, my lord, PCR was called for, my lord. And that was, my lord, received, my lord.
No, he's sent up for trial. Deep Jyoti Soikyan. Yes, he's sent. PCR was,
Yes, my lord. His, my lord, name is there, my lord, and it is a case of theft, my lord.
no, just a minute. I'm getting confused. You
I have flag mark, my lord.
Dhing PS case number 201.
Yes, yes, my lord. Yes, my lord. That case, my lord.
He was granted interim bail.
He had interim, my lord.
He has appeared.
He, my lord, appeared. In the meantime, my lord, charge sheet was submitted, my lord. And my lord, there it is stated in the charge sheet that, my lord, he appeared. But my lord, as per my lord, there is a written record which is available with us, my lord. He is the kingpin, my lord, because my lord, the Bolero was, my lord, taken, my lord. And he is the mastermind along with another co-accused who is also not, my lord, they, my lord, filed the charge sheet as an absconder. Along with them, my lord, these three people, my lord. One Deep Jyoti, another Asidul and Mehfuz, my lord. These are the three people, my lord. And my lord, during the course, my lord, another two persons, my lord, one Bastop Soikia and another one is Noyan Jyoti Soikia, my lord. They were arrested, my lord. And those people are hired by this Deep Jyoti Soikia. Otherwise, my lord, the vehicle was recovered. My lord.
So at this stage, what do you?
But my lord, again, material search.
Petitioner is a student, Lordship.
Obviously, my lord, they are student, my lord, and that is the, my lord, greatest tragedy, my lord. Being student, my lord, they are involved with all these cases, my lord.
That's
All these cases, my lord. Let me kindly peruse, my lord, in the, my lord, PCR, my lord. Being student, my lord, they are involved with this kind of, my lord, activities, my lord.
Everyone needs lots of money. Is seeking lots of money.
But the vehicle is recovered from the other person, Lordship. Already they have got red-handed, Lordship. But mastermind, that is the allegation only, Lordship. So let him, Lordship, and he will
Actually,
be
it was
appear
not
and
a
face
case.
face the trial, Lordship.
It can be done now. Anyway. Subject to conditions. Absolutely. about 15 times. Additional Auckland Council and additional, Cape Oyster additional. There are 2, 3, 6. The petitioner was granted interim bail on 15/9/2025. Scan TCR was called for in the context of charge sheet having been filed on completion of investigation. Right CS number 209/25 dated 23/9/2020. The present petitioner has been sent up for trial. Other charge sheeted persons are on bail.
Lordship.
All are on bail.
On.
The other charge sheeted persons are stated to be on bail as submitted by the learned petitioner counsel.
My lord, they are in regular bail, my lord, because they were
Re-
arrested.
Regular bail,
It is a case of pre-arrest.
regular bail. Yeah, strictly speaking, actually, it is kingpin. should
Yes, my lord, because my lord from CDR and everything, my lord. He is the person who gave a call that my lord, one car is there, I need a driver. These people are there, my lord. They are also, my lord, his classmate, my lord, one Noyan Jyoti.
What are the sections then? You
The
can,
section they use,
can
my lord,
say-
this 303
you can appear and seek regular bail also.
That can also.
That can also be.
Yes, my lord, time may be given, my lord. In the meanwhile, they can go, my.
Charge sheet under which sections?
My lord, 303 my lord.
That is magistrate tribunal.
Makes the tribunal.
Yeah, there. That can also be.
May absolute lordship, and after receiving summon lordship, he will be appear.
Though the prosecution has submitted that they are implicating materials against the present petitioner and rather his investigation has found him to be the main person main person behind the alleged offences in which other accused are also involved. But considering the completion of investigation, rejecting the bail at this stage may serve limited purpose and that limited purpose also. Therefore, I'm of the view that the interim should be made absolute, subject however to suitable conditions. Accordingly, the interim order dated so and so is hereby made absolute, subject to the condition that number one, he shall be available for the trial. Number two, he shall not hamper or tamper with evidence. He shall not indulge in any activities or offences. In case of violation of the bail condition, the bail will be liable to be cancelled. Bail petitions disposed.
Obliged lordship.
That is why the thing, that
My lord.
interim is given on some certain,
My lord.
sometimes prima facie or
Yes, my-
sometimes even superficial satisfaction.
Right.
Therefore, you need to get the case diary without
Yes,
much
ma'am.
delay.
Basically, my lord, in those cases.
It's not a final call.
Yes,
A very interim means interim call.
my lord.
Sometimes it's there.
Yes, my.
No, nothing to do with
My-
general.
Especially, my lord, in those offenses, my lord, in
Sometimes.
capes, my lord, that is the, my lord, and others, my lord, dacoities, robbery.
Because IO never got a chance to custodially examine
In my,
this.
my, extortion and all.
Absolute law.
Absolutely.
Lordship.
Well, it's in time home. Time.
Item number 33, the arguing counsel is on legs, my lord. Maybe Mark may pass.
Sometime
Obliged, my lord.
after second half.
And the CD not received, my lord, otherwise interim is there, my lord. So we pray for a next date, my lord.
The girl went missing. Huh?
But the girl was recovered.
Recovered. Anyway, the case diary It's not yet received. Issue reminder for the same. Interim granted, interim protection granted by the order dated 13/11/25 stands extended till the next date of listing after which.
My,
When-
my date may be fixed, my,
You can suggest a date.
my lord, 7th, my lord, 7th of January.
Much obliged.
May I please? 482 application lordship, FRB is based case second lordship. Here is a allegation of assault lordship. Actually, there is a allegation of assault of Khamti Dam, but this is not true. Lordship. Actually, what happened is that the informant is always still fished from the fishery of the petitioner lordship, and on the day of incident lordship, petitioner went there his fishery and found that the informant catching the fish, and when he found that the petitioner assaulted him with a bamboo fence stick lordship, not as a khamti dam. This is true that the petitioner assault, but he is not assault with khamti dam. The assault with bamboo fence stick lordship.
There has been.
Yes, case they received.
See
Not
the
my lord,
injury report.
yes, injury report received, my lord. Injury, my lord, laceration of scalp, my lord, grievous injury by sharp weapon, my lord. It is not by bamboo, my lord. And eyewitnesses implicated directly the present person, the present accused person. Two injuries, one grievous, my lord, scalp, and my lord, in one simple injury below elbow to left hand.
Then it may not be justified. AB, right?
AB lordship.
Regular bail, it was. Investigation is going on.
Investigation, my lord, going on. My lord.
This to always complete. No? Petitioner will cooperate lordship. Investor will not cooperate lordship. Yeah.
He survived, right?
Lordship.
He survived.
Yes, my lord, survived.
Or his statement is available.
No, my lord, this is
This is
his
not- he's
injured
not in-
statement is not available. Regarding that, my lord, I will try to, my lord, note any notice there. Otherwise, two eyewitnesses, my lord, specifically implicated that he is the person, my lord.
Because he is still he's always lordship. That's why he is
Injured is one, my lord.
He heard Desi Gogol.
B Islam lordship.
He is and no TP. He got 483 bail 482 bail application. Hilamara PS case 339 of 25. Jahar was lost on 22/10/2025 for the Hilamara PS with the allegation that the informant was he himself lost the FIR. But he was working in the farmhouse of on Upendra
He himself lost the FIR.
and on 21/10/2025.
Incidents occurred on 21 and he lost the FIR 22 after 1 day.
That is a bit.
Yes, my lord, he himself.
On 8 p.m. on the way to 8 p.m. on the way to Meleki, and then the accused assaulted him with a khamti dam, and due to which he sustained grievous injury on his hand, back, and head. But the medical
My
report is
police
telling-
has, my lord, recorded the statement of the injured informant, but his statement I have not found here. Only the note is there that examine the
Yes,
component of
injury on the head
head, my lord.
by a sharp weapon.
Sharp
The
weapon.
Next day, the person difficult.
Yes.
Difficult.
Difficult.
It's contrary, a little, contradictory with human logic. But
Yes.
it is telling. The medical report is telling.
Yes. Scalp, my lord. By
The
scalp.
case diary has been received, and it is submitted that the medical report reveals grievous injury on the skull caused by sharp weapon. The two other witnesses stated to be eyewitnesses. Eyewitnesses, right?
Yes, sir.
Are all, have also implicated the petitioner as submitted by the prosecution. But his statement is not available. Right? In the given circumstances, it may not be a fit case for grant of 3 years bail. And accordingly, the petition is rejected. Return back the case.
Much obliged.
Very pleased, Your Lordship. The prayer is bail applications. All the petition from Lordship here belongs to same family members. Your Lordship, find FIR page 13, the entire incident is part of the trifling matter of releasing air from the four wheels of the informant's vehicle. Page 13, my lord.
Let us read it.
Yes, my lord.
You can read it.
Respectfully beg to state that today on 21/9/2025 around 9 p.m. at night, I received information that somebody has released air from the four wheels of my vehicle bearing registration number so and so, parked at Bamungao Sariali. Upon receiving such information, my elder brother Azimuddin, aged about 50 years, proceeded towards Bamungao from home. During that moment, accused person staying there in premeditated way, coming by Bolero and Swift vehicle, armed with iron rod, wooden sticks, and sharp weapons, intercepted my elder brother named Azimuddin and allegedly attacked him. My elder brother sustained grievous injuries on his head, nose, feet due to assault caused by dog, cutlass, stick, and rod. Accused fled away from the scene as soon as local decided and family members arrived at the scene. My elder brother was shifted to hospital for treatment in unconscious state. The police personnel carrying patrolling duty could able to apprehend two accused person with an intention to kill my elder brother, inflicted several injuries. And during the course of investigation, my 2% arrested, accused number 3 and accused number 5 as named in the FIR, my lord. So far as the petition number 9 in this case, my lord, during the pendency of this antecedent bill application, he was arrested. Petitioner, his name may be struck off.
9.
9, my lord. And after 7 days, he was released on bail, my lord. The other two accused were there also arrested but released on bail after 7 days. The way the story has been, my lord, depicted in the FIR, that is not the, my lord, gist of the case. The gist is that yes, we, my lord, resident of the same locality, at 9 p.m., my lord, we found that one vehicle was parked at Bamungao. Then we made a through search. Then we made through searching to find out who is the owner of the vehicle. But we did not find. Then we released the air. It is a true, my lord. To release the air of the fuels of the vehicle. Having received information, my lord, el driver of the rush to the spot with 2 or 3%. He started altercation with us. He could have, my lord, resolved a dispute through negotiation. Instead of doing so, my lord, he started quarreling with us, my lord, and which led to fighting. Resulting, my lord, one person from our side and one person from their side got injured, my lord. That is true. But it is not that, my lord, the way case is projected that it is, my lord, assaulted by a lethal weapon, my lord, with iron rod, cutlass, dog, and this is not a true, my lord. And so far as the petition number 10 is concerned, my lord, he is after completing his, my lord, graduation in commerce from Guwahati Commerce College, now pursuing his IS coaching in Ajmal IS Academy. On that night, my lord, he was not present, my lord, and he also made an application to the officer in charge along with the CCTV footage that, my lord, on that particular night, when the incident was reportedly took place on 21/9/2021 at 9 p.m., at that moment, he was in academic campus library from 6 a.m. to 10:30 p.m., but you also find page 20, my lord. That is the application. So far as, my lord,
In this petition, how many petitioners are there?
my lord, and now initially it was 10,
10.
now it is 9, my lord. Since one is
9.
arrested, my lord.
9.
9, my lord.
14 has been arrested.
Yeah, sorry for not Tajuddin. Petition number 9. There are altogether, my lord, at 12 accused as named in the FIR. Accused number 3 and accused number 4 as named in the FIR arrested and released on bail.
I've got it.
My lord, contents of the FIR itself reveals there has been foundation to make out a primary physical in the petition.
Investigation.
Yes, we have the CD, my lord. My lord, kindly produce the CD, my lord. Injury report is also.
Can you submit
available.
from there?
My lord.
Will you be able to submit from there?
Yes, my lord. My lord. My lord, here, my lord, that is, my lord, there are total 10
I'll also
number-
see, but you can submit also.
It's only arrested.
10 numbers of my lord, that is the petitioners are there.
Nine
As
now.
stated, my lord, the petitioner number 9, Tajuddin, who is arrested on 19/11/2025.
Nine,
Come, my lord.
12, 3 were arrested and released on bail.
No, my lord, before your lordship, my lord, now, my lord, 10 numbers of petitioners are there, my lord. Before your lordship. And amongst that 10 numbers of petitioner,
One was arrested.
petitioner, one was
Infractions.
arrested, my lord. So now, my lord, 9 numbers of arrested. In the FIR, my lord, there are 12 numbers of names are there. Now, before your lordship, 9 numbers of accused petitioners are there, my lord. Now, my lord, in this case, my lord, that is all these 9 petitioners, those who are, my lord, FIR named and also implicated either by the, my lord, that is the victim or, my lord, the independent witness who at that point of time, my lord, very much present, my lord. My lord, may kindly peruse the, my lord, that is the injury report, grievous injury, my lord, and the statement of the, my lord, that is the witness, my lord, independent witness, and also the victim, my lord, where, my lord, very categorically stated. Regarding, my lord, that is the another part, my lord, that is the, my lord, petitioner number 10 of the petition, Asif Ahmed, where, my lord, it is stated that regarding a pen drive, my lord, that pen drive, my lord, was, my lord, police, my lord,
He
my
was
lord,
in the coaching institute.
my lord, but that is a pen drive, my lord. That is not the seal, my lord. Those things will come out after, my lord, the FSL, my lord, when it is sent. But, my lord, that is the statement of the victim, my lord, which clearly stated that he at that point of time very much there, and, my lord, he was beaten by that person, my lord. My lord, all these portions, my lord, I have, my lord, flag mark. So, my lord, it is a pre-arrest bail application at this stage, my lord. My lord, my lord, there is a prosecution's, my lord, humble prayer is that, my lord, it is not a case, my lord, to grant, my lord, pre-arrest bail at this stage.
The victim is Azimuddin.
Yes, my lord. One
He-
photograph also, my lord,
ENT
during that
bleed.
time, my lord, police, my lord,
Severe,
procured, my lord.
severe nasal bleeding, loss of consciousness, vomiting. Plant object.
One photograph also, my lord, police, my lord, procured, my lord. During the course of investigation, my lord, it is also come to light that there is a kind of dispute between them, my lord. Many affairs were lodged, but, my lord,
Yes.
because of that, my lord, that if there is a dispute, nobody can go in such a way that to kill a person, my lord.
Yeah,
Very brutal way, my lord.
He's in treatment problem.
My lord, my lord.
Victim.
Not at this stage, my lord. All are implicated, my lord.
What is the statement of the victim says?
Yes, my lord, victim, my lord, implicated, my lord, the last part of the CD, my lord, his statements is there. Maybe,
yeah,
my lord, that is a green flag mark is there, my.
Video footage would have to be forensically tested, verified.
Not, my lord, only a, my lord, pen drive, my lord. A pen drive, my lord, thereafter, my lord, was recovered. That part also, my lord, I have flag mark. One horizontal flag mark is there, my lord. Last part, my lord.
Yes, I've seen.
Yes, my lord. Because, my lord, that is not, my lord, through the proper way, my lord. It is somebody has sent, my lord. Maybe that may be true, my lord. But it's after, my lord, all these things, my lord. But, my lord, now present we have that, my lord, victim who is, my lord, brutally, my lord, beaten by some people, and his statement clearly indicates, my lord.
Heart, limb, and voice of learned counsel. Standard hearing. Invoking 482 BNSS, the petitioners, the 10 petitioners had filed this petition in seeking anticipatory bail in connection with Lanka PS case number 203 of 25 under so and so section. It is submitted by the learned counsel that during the pendency of this petition, the petitioner number 9, Tajuddin, has been arrested. The case arose out of an FIR dated 21/9/2025 lodged by Burhanuddin. 12 persons are named in the FIR. The allegations is that on 21/9/2025, in the night at 9 p.m., somebody released air from the four-wheelers of their vehicle, bearing number of his vehicle, bearing number AS02 AF4989, parked at Bamungaon, Sariali, in that area. And upon getting this information, his elder brother Azimuddin, aged about 50 years, proceeded there. And then the accused persons in a premeditated manner came by Bolero Swift vehicle and armed with iron rod, wooden sticks and sharp weapons. It is alleged, full stop. It is alleged that thereafter they intercepted his brother and attacked him, causing grievous injuries, and thereafter fled away from the persons. It is alleged that the accused persons attacked his brother with the intention to kill. The Petitioner Council submits that as per his instruction, there was minor altercation with regard to some releasing air from the vehicle as alleged, but the narration in the FIR is highly exaggerated and distorted. The case diary has been received along with the medical report. The learned prosecution submits that the medical report reveals grievous injuries caused by blunt object on head, on the head of the victim, alleged victim. Full stop. It is submitted by the prosecution that apart from the victim, there is significant implicating materials against the petitioners, all the petitioners, with regard to the contention on behalf of petitioner number 1, petitioner number 10, Asif, right?
Yes, madam.
Asif, that at that time he was in a different place undergoing coaching and submitted a pen drive in this connection. The learned prosecutor has drawn the relevant portions of the case diary, and that the veracity of the said electronic material is a subject of investigation and forensic examination. In view of the immersed circumstances and materials, this may not be an appropriate case for grant of pre-arrest bail, especially when investigation is not yet complete. Accordingly,
In this case, 30 submitted on my lord, 30th August, my lord, 38/25. my lord.
oh, quite long time.
25.
Yes, ma'am. Earlier, my lord, there was a direction of this honorable court to surrender, my lord, by granting interim protection on very ground, my lord. Take the order of the, you also may kindly peruse order dated 14/10/25. In that order itself, there is mention about the circuit number and date.
Oh, reflected all.
Order dated 14/10/25.
Which member, which case? Oh, which case?
14/10/25. It is number PN number 3151, number 51.
Oh. Yes, 116. 116 of 25.
Yes, 116. Thereafter, my lord, then last portion, my lord, the accused applicant failed surrender because of the judicial magistrate Kamruk on or before 7/11/25 positively. In the event of his surrender, the instant interim bail order shall be deemed to be cancelled and the police authorities regarding present immediately. And regarding my lord, so in that case, within the my lord, it submitted within the period of my very
Statutory period.
Justice submitted.
Only problem is that his, otherwise investigation is completed. The problem is that
It is completed.
he's involved in a host of cases.
Yes.
So that is, anyway,
Look, no, custom detention is not necessary, my lord. So for this case, also because other case, your lordship, madam.
Their only difficulty is that my while the honorable court has directed him, yes. your lordship,
I told you, no, that they actually our order extending interim, now it is extended. Now
in
he
that
can,
case also, my
now we
lord,
cannot even blame him because we have extended that order is actually slightly erroneous.
Yes. But my lord, regarding that computation of that period, whether that my lord period,
Oh,
in
investigation
which
is
my lord interim period
That I'm not.
was done, whether that can be my lord, can be
That I-
counted, my
judgments.
lord, equal bill or not.
In this case, it, charge sheet
in
was filed within period.
Within time, but in this case, that
Does not apply.
my prayer was. While there is election of this, your lordship may otherwise on merit, your lordship may consider me. There is no difficulty, my lord. Or if my lord, if your lordship.
Yeah, that's true, that's true. Anyway,
We'll have to
Otherwise,
anyway
while there
surrender
is direction
one.
to surrender before this.
Yes, yes. I in one case, anyway, I have to surrender. Already your lordship directed surrender.
So my
So
lord.
I'll have to anyway go in.
Maybe my prayer because if let him at least surrender before the trial court, and there are trial court will consider in echo because there is a direction for surrendering him. My lord, in a particular period. Till now,
then
my
the
lord,
interim will be
that
extended.
order.
It the interim is
Till
extended.
now, he has not surrendered. In
No,
pursuance to the order of this.
not, it's purpose.
Yes, otherwise, extended.
Anyway, this I am disposing. Third. We bought up 14, 10 or second paragraph. Second, third and second, third paragraph. On the projected hell grounds. So, the petitioner was granted interim bail on 14/10/2025 with some conditions. The same was, however, extended by order dated 8/12/2025. The diary was called for, but in this context, the learned additional PP submits that is completed in this case, resulting in a charge sheet in which, in this charge sheet, he along with who sent up for trial, you're not, probably cannot say. He, apart from him, somebody,
Wife, my lord,
He-
whether he.
that we don't, that we don't.
Not.
He has been sent up for
Otherwise, in
trial.
many of the cases,
Trial,
he and
full
his
stop.
wife.
Mm.
So my lord, is a-
It is submitted by the prosecution that there are several cases pending against him.
No, 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 why?
I don't know. However, in view of the completion of investigation in the instant police case, I do not deem it. I'm not inclined to cancel the interim bail. Accordingly, the interim bail granted to the accused is hereby made absolute, subject to the following conditions. Number one, he shall be available for the trial and shall appear before the learned court below slash learned trial court on the dates. Number two, he shall not hamper or tamper with evidence. He shall not misuse his liberty to commit any illegal activities or offences. If this bail petition stands allowed and disposed of in the court sentence. This is done. Now 52.
52.
Right?
Yeah, also same question, my lord. that-
Yes,
Yes.
yes.
Here, my lord, I would like to.
Investigation is not completed.
Yes, petitioner, I will point out regarding that. Here petitioner was arrested on my lord 11/8/2020.
Just 10/8/25, 10/8/25. And custody period is released on.
Released on 23,
he re-
14/10 interim done.
23/10 he was released.
My lord, on 11/8/25, he was arrested. an interim bail granted
On
on held ground on 14/10/25.
yeah. But
That was, my lord, at the 67 days while he was in custody. It was interim bail granted. And regarding aiding of section 111(2), on 111(2) aided much prior to that on 5/6/5th of June. So, my lord, it is not that, my lord, recently that a section was added, my lord, before immediately.
On 5/6 only.
Yeah. So on 5/6/20. Yes, sir. And regarding, my lord, whether during and other seasons.
আজি মোটামুটি কিমান দিন হ'ল? আজি
Investigation is not complete.
Not
one
complete.
120 days. More than 120.
Yes. Regarding that aspect, my lord, whether the petitioner is entitled for default bail and whether the period during which petitioner was granted interim protection, whether that period can be counted for, my lord, granting default bail to the accused or not. Regarding that aspect, I would like to place your lordship.
We found any case law?
That cannot be.
Logically, yes.
Can consider the bail petition only on merits.
No.
No.
At that time, it was, the 90-day period is over. 9, 10, 11. Yes, it's over, but the 90 days is past, but this is
past.
Kerala High Court.
Circuit not yet submitted, but regarding that aspect, that period was under interim petition, he was not in actual custody, my lord. So that period cannot be here, my lord, exactly the same case, my lord, Kerala High Court, where the petitioner was arrested on 18/2/25. At the first tense, he remained in judicial custody till, my lord, 24/5/25. On 24/5, he was granted interim protection. Ultimately, while discussing various laws, my lord, ultimately,
একটা কপি
Logically, yes. This, we have not found yet a Supreme Court judgment.
Yeah, we have there is Supreme Court judgment with about the constructive custody.
We should be clear about the position of
Yes, yes.
regarding, my lord,
Kerala High Court judgment.
this is, my lord, regarding
Recent decision. Anyway, let
This judgment, in this judgment, two judgment are relied. Where there is a constructive custody,
Yes.
even if he is released,
there is no doubt that petitioner is under constructive custody. Yes, but that is also a, my lord, that while
Para
petitioner
12,
was
if I-
granted interim protection by this honorable court, although he was not a free man while under custody from this matter, he was allowed to, but he was not in, my lord, actual custody of this.
this one, which one should I see, sir? Which one should I see?
Supreme Court
Sandeep,
judgment.
Sandeep Bafna.
Yes, Supreme Bapna.
It's a very old case.
It is
Famous
a old case and
Sandeep Bafna.
yes, Odisha High Court, relying on this, Odisha High Court has passed the judgment. That para 12, if you also go to para 12,
Of Sandeep Bafna.
no, Supreme Bapna 12. It's a copy, yes, sir.
If it is two different high courts, then if two different views,
Two different views.
not yet settled.
Not yet.
Any judgment of our high court? Then we are
Regarding actual custody, my lord, I have. Regarding that aspect, my lord, where here only discussion is regarding the, my lord, some custody, my lord.
logically it should not be counted, but the principle of constructive custody, yes.
Yes.
That also
It's personal
appeals.
custody, yes.
That is also appealing.
Yes.
That principle.
Regarding that aspect also, I would like to place one another High Court there. Yet that in that case, my situation was slightly different. That in that case, what happened initially, the petitioner, the investigation was conducted by the state police, my lord, state police of the, my lord, Kerala, and when petitioner was initially granted absolute bail.
Mhm.
Thereafter, my lord, state has challenged that order of granting absolute bail before the Supreme Court. Then on the basis of the, my lord, letter, Supreme Court has cancelled the bail, and thereafter the investigation was handed over to the CBI. CBI again, my lord, arrested the accused person. Then he filed a bail petition, considering that while earlier also he was in custody for a particular period, And there are.
No, that is counted.
Everything, yes,
That is counted.
that is.
That I know. Because police investigation,
counted.
then CBI, NI, that from the initial.
Yeah.
Like
That is-
transit remand is also counted. Transit remand is also.
That was not, there, but here.
That
the
is
question of interim bail, because petitioner is not in actual custody, but he is although constructive custody is there. But as per the provision of the.
Well, if your lordship go through, if your lordship go through my Odisha High Court judgment, para 2023 clearly written. Odisha High Court judgment. Para 26-27. Odisha High Court.
I'll go, just.
I just read that judgment.
No, that's why first we have to find whether Supreme Court has spoken on the issue.
Spoken of
Supreme
the-
Court has spoken, then nothing else matters.
Yes, Supreme Court is.
Supreme Court has not spoken, then we have to see
Yes,
what
yes,
our High Court has spoken.
Supreme Court, that's why Bafra is written there, every what are the meaning, what is custody and
In
what.
Bafra, has it been said that it
Yes,
is
yes,
counted or not counted, whatever it is?
But
Legal
yeah,
coach.
but specifically
Not specifically not.
not
stated.
specifically counted, but this thing is
But here in the.
based on this, Kerala High Court, Parakavil, they don't discuss on this.
Which para?
26-27, Odisha High Court.
I will go through it.
Yes, Lord.
Probably it has not been specific, it has not been.
Is it specific? Here is
There's
specific.
no apex court judgment, it seems,
Yes,
on this
there is
point.
no apex court judgment clearing them, but here in this judgment,
No High Court, our High Court also probably, we have to search, do some research. Anyway,
here in this judgment.
But Odisha High Court is different. Odisha High Court is different.
Fiscal.
Supreme Court judgment.
मतलब fees है, versus state of Kerala, मतलब here the.
Odisha High
But
the fact is same.
But if you lordship go through Odisha High Court judgment, you will find that relying on the Supreme Court judgment, he has passed this order.
That is Niranjan.
Niranjan,
yes,
Niranjan Singh versus.
I will pass this order later. You have done homework both sides. I should. You will study it.
Where the third lordship, my lord, your lordship may consider it, but at this point of time, because petitioner is under interim.
Is actually, are you seeking default bail also? Default bail is one aspect, otherwise merit also is
My prayer before lordship to consider the.
on merit.
bail on the.
Merit also.
But he is also seeking because at that time, it was added on 5/6, thereby making it 90 days. But 90 days is over if we do not count the period of interim.
Yes, because if we go by the provision.
So in that sense, this is relevant also.
Provisions of 187 BNS and earlier 167, my lord. So under three circumstances, my lord, 439 can be, my lord, an application under 439 can be filed by the petitioner. Herein, my lord, if police arrested and produced a person before the trial court, my lord, and when in a case where police not yet arrested, but even if the person himself renders before the trial court, my lord, then also trial court without, it is not required that in all cases only after arresting by the police, after and producing before the trial court, then only bail can be considered. If person himself surrendered before the trial court, then also at that point, if file bail application, then also my lord,
That is what
trial court
Sandeep
can
Kumar Bhapna
consider his bail application.
That is what Sandeep Kumar
There's something over clearly written on the thing.
That is
So
Oh, my lord, my full submission before. your-
diary has come here.
Yes, yes,
You give me, I'll pass. I'll do some study and necessary.
my submission is on the ground that petitioner is not in actual custody as per the requirement section 150.
And my lord, if
Petitioner is not in actual
Just a
custody
minute.
under that circumstances, he is not entitled for default bail, only on merit your lordship can consider.
Because if we count the period of interim bail,
Yes.
then a statutory period is over.
Yes, and in that.
That's why it's a relevant
And whether
consideration.
Kerala High Court has taken the
Kerala High Court has taken now.
has taken consider.
I'll see. Kerala High Court has,
Yeah, they taken a different view, but
No, has
but Odisha High Court has taken another.
Sandeep Kumar Bhapna.
yes, Sandeep Kumar Bhapna, yeah.
That's why I said, no, if on a particular, obviously, we all know that very obvious thing I'm
It
saying,
is a prerogative, huh?
reminding myself that if in a law point, the Honorable Supreme Court has spoken, academically, you can always discuss as a student of law, but as far as precedent is concerned, that is the last word. If the Honorable Supreme Court has not spoken, then we see what our High Court has spoken, especially a division bench. And then if there's nothing, then other High Courts are persuasive.
Yes, yes.
Then you have the flexibility to take a different view, or you may concur also. Judgments of other High Courts also have considerable persuasive.
Yes, yes. The
Because-
Kerala High Court judgment, what is there is difference? Bhapna case. He served the Bafna case, my lord.
Otherwise,
Otherwise, it is parallel case.
if it is not. This is another famous case of High Court, Pranab Roth.
Although my lord, KS suppose, my lord, son of the Kerala High Court, my lord, it goes against, although actually, however, in that case, my lord, all the instances of the Supreme Court, including Rakesh Paul, everything was.
Which one? Which case?
Rakesh Paul, Rakesh Kumar Paul, but it.
That case.
Everything was disturbed.
In which case?
That is, my lord, KS Sabu, my lord,
That,
versus CBI.
the Kerala High Court judgment.
Kerala, that is goes against us because at that point of the petitioner was not on interim bail, but initially investigated by the.
Yes.
Oh. And at that point of time, it was
Tabu,
for a particular period, and thereafter while handing over to the CBI, then also
No.
for a particular period, he was in custody, then he approached before the trial court for the full bail. Then my lord, Supreme Court observed that, my lord, because he was in custody.
My lord, the Bafna, the 11th para, page para 12, my lord. Bafna, the Bafna.
Now,
It appears to us from the above analysis that custody, detention, arrest is sequentially cogent concept. On the occurrence of crime, the police is likely to carry out the investigation, interrogation of person, in the course of which the liberty of the individual is not required. Suspects are then preferred by the police to undergo custody interrogation, during which the liberty is implemented and encroached upon. In Roshan VV, the full bench High Court of Madras, speaking through a Ratnavir Pandey, just held that terms custody and arrest are not synonymous. Even though there is every arrest, there is a deprivation of liberty in custody, but not vice versa. This thus resulted in by Pandian judge in Deepak Mahajan by depriving support from Niranjan versus Toronto. The following passage from Deepak versus what extraction. So here that word custody is totally defined, and what. But this part is not discussed in the Kerala High Court judgment.
That becomes parting to
So it became parent.
Bafna is actually also an authority, and this is
It's a constructive then.
Pranab Roth.
Yes.
You know, this is
It's
also
constructive custody.
This is also another interpretation. Actually, these judgments have also addressed this issue which we keep tackling. You know, kept coming up, that Sessions tribal case, bail, Sessions tribal case. This has been clarified here also. That Sessions tribal cases, this is also one of the original judgments. And here it has been also said in these two judgments, Bafna and that in a Sessions tribal case, supposed punishable life imprisonment, a person can go to the Sessions court, appear, surrender, and if the Sessions court accepts his surrender, then he will be taken to be into custody of the court, and then the court can actually give him 439 bail.
Yes.
This has
On
been said.
that day, my lord, particular day, my lord, state court can grant, my lord, or reject.
My
Police, without producing, arresting by the police.
If you also consider the Kerala High Court, I just point out
I
that
see.
better Bafna is better about the case of Bafna is better mentioned in the Kerala High Court.
Kerala High Court judgment?
No, it is not mentioned because they are not given emphasis on that, and it will become part of the
merit of the case.
And merit of the case to say
In page 23.
Page 26,
On 1920.
that.
Regarding this point is I'm clear that if this change in investigating agency,
In that
it
case,
won't make a difference.
because he is, at that point, he was under the custody, not on interim bail.
Even transit remand is calculated
Yes,
because transit remand is police remand.
under the custody of the police. Here in this case, my lord,
There is a
the
111.
person, liberty of the person
There is a
was not
190.
curtailed. In fact, it was a given, but with certain.
Yeah, logically it should be excluded actually. Logically.
Yes.
And so for merit
And
is concerned, my lord.
also, my lord, not specifically stated whether that period should be excluded or not, only stating about constructive custody. But regarding this point, that, my lord, that during in period, but here in this Kerala High Court judgment, my lord, clearly, my lord, the same fact, my lord, ultimately, my lord, excluded the period during which the petitioner is in.
I had given you an example. Will not waste time with I had given you an example. Suppose a person is arrested due to some circumstances. Their life has admits of various circumstances. Suppose day after tomorrow he is given granted bail, and then and then a 60-day period on the 58 days he's on interim bail, and then the charge sheet is not submitted. Can I say that the period is over, I must get statutory bail. Can I say that's the thing?
No.
Logically, no.
No.
But if the again I said, if the interpretation has been said for some reasoning, then we have to accept that.
Then
Otherwise,
Miller,
different high
actually,
courts
but
can
then
take
my-
different views.
You're looking at accept it onto under 187. Actually, my lord, investigation should have been completed within 24 hours. At the first day.
Yes, yes, that's-
Thereafter, my lord, that
Yeah.
extended, my lord, up to 60 days or 90 days. During that period, my lord, while the person, especially the word custody is there. While petitioner is under custody, so custody means actually.
In one point, this court is, this thing I want to point out, he is already in custody for his 74 days. What that, during that time, what they are doing, police? They don't, during that, they should have completed the investigation. Why not? They till that time they have not, they cannot complete the
You
investigation.
cannot complete the investigation for that reason, my 60 days, 90 days. period, like-
If you go to page 26 of the petition, armed second added later on, armed sec. 1925.
Technical difficulties there also, my lord.
One says,
One example.
one hundred eleven doesn't.
I'm reserving this, but I will deliver it quickly. Because the factual part won't take time today only, but law point, I don't know if I have to go deeper. Because it involves statutory bail aspect, right? Civic. The interim bail, however, stands 10 extent.
1927.
I heard for this. Case diary, you kindly submit the case diary. Case diary submitted shall be written, resolved, and interim bail stands extended till the next date of this. Do it within this week.
You know, there was in this type of case, again, traffic, thereafter, in many cases, they will again come on the hell ground, thereafter. Aspect of law. Without, my lord, taking it and what is, my lord,
My lord, if I just say something that for purpose of simply putting the person in jail and interrogation, it will not serve any purpose. You already, because whether it is a penalty or not, because it is not that.
Yes,
but
11 cases against him. Anyway, we'll not go into that now. That's why I gave you that example. No, suppose out of 60 days, 58 days, someone is on interim bail. Then can I say that 60 days over, I should get? Logically, no.
In that case, your lordship has to consider only on the merit, not of the ground of, my lord.
Anyway, I'll look into it.
The interim order extended.
That I'll have to extend, because I'm reserving. I'm taking time, so it has to be extended. Within this week only, hopefully. Oh.
May I please, your lordship?
Yes.
As per my, they have not filed a file. There are 27.
This is item.
27.
We had kept it for what?
My lord, the record was not, my lord, that time we, for that purpose.
Okay.
Second, I would like to point out that in this case, at the time of filing this petition, traffic was prohibited. So scan copy was called for, that has to be qualified as the registration. So our office has not even told to be paid there, because at the time of filing the petition, my lord, traffic was prohibited. He has annexed in the petition.
25, 258 to 24 more cases. Don't approve.
What is the allegation? Then we can, otherwise you can dispose it of.
No, it is.
Interim is there. Nothing, what is, I think there's it's homicide. Yes, yes.
On 17th, your lordship, I will get the
CD or CI can record.
CDU. CDU,
TDU with FSL and postmortem report.
yes. CDU.
The case diary is not received and learned additional people. Praise for listing the matter on 17th for procuring the case diary along with FSL.
Yes.
Prayer is allowed. Interim bill passed earlier shall continue till the next date of listing. List on 17/12.
Oblige, Lordship.
The officials provided in item number 27. That place my lord substitute. So my lord.
Well, please, here the CD is awaited since 3/11. That was initially granted interim bail by the Sessions Court at page 41. This is an
Yeah,
F.
it was this
The only non-bailable offense is 1182, grievous hurt. So what had happened here, the FIR, my lords will find at page 27. 27 is the FIR. It is an FIR pertaining to assault. And but it's awaited since 3/11. There is a cross FIR which I filed,
Just a minute.
which was not registered. Ma'am. And accordingly, I moved before the Sessions Court at Rongia. And I was granted interim at page 41.
Just a minute. Multiple assaults are alleged
Yes.
by.
But while the medical report is, I'll just take my thoughts through. Page 41 is my
Order.
interim pre-arrest.
41.
41. Last para, after perusing FIR, submission of learned counsel, it appears that the viva has also filed one FIR regarding one occurrence on the same date, though it was not registered. But after perusing all the documents submitted by petitioner and submissions of the petitioner, I am of the opinion it is fit case to allow ad interim bail. Now this happened, and then at 43 my bail is rejected, ad interim is rejected. And the medical report, my lord, will find from page 46, which don't show any grievous hurt. The only non-bailable section is 1182. That is verse 12, 326.
326. 46. Page 46.
46 onwards. And if my lord sees as 47, impression, no significant abnormality detected, clinical coloration and follow-up.
Chest X-ray.
Chest X-ray, it shows normal at 48. Then pelvis X-ray also shows normal at 48. 49 is again the review of chest X-ray and the spinal X-ray.
Just a minute.
Bottom of 49.
Diary has been received.
Diary is not received since 3/11.
But later on, after perusing the CD,
It was like it. We'll need the CD as well as medical report.
May I only request a shorter date?
Yes.
Case diary has not been received as yet. Learned counsel admits that the matter has been pending for case diary since 3/11/2025. The case diary, the IO is directed to send the case diary expeditiously and positively on the next day, for the next date, along with medical report. List on
16th or 17th?
17.
17, 16. Which thana?
16th?
Which thana? 16.
16th. I'm grateful.
Which thana? Guwahati? Rongia.
Wrong here. Not too far. I'm grateful.
16. Pending the
Which item 40?
June.
40. It was 40.
After some.
I can 13, my lordship.
13 file was.
Not where
12.
May I please, my lord? My lord, it's a criminal petition filed under section 482 CRPC for setting aside and passing of a criminal proceeding initiated in PRC case number PRC 928 of 2023 before the Honorable Court of Learned Munsif comes MFC 2, Vilasipada. Your Honor, Your Lordship, in this matter, there are 4 accused petitioners and informant is the relative of the petitioners.
Right.
Informant is the sister-in-law of the accused petitioner number 1, Your Lordship. So the FIR in this case is at page number 22, Your Lordship. The allegation is that the accused petitioners, along with some miscreants, went from Guwahati in their car carrying some weapons like lathi, da, dagger, and sawal, with an intention to grab the land of her husband's ancestral property.
Informant's husband.
Her husband, Lordship, measuring 24 biga. That is the ancestral property. That is the allegation. And along with some miscreants, they attacked her husband. And when the informant and her daughter went to save her husband, they were also attacked by the petitioners. That is the allegation, Your Lordship. And one more allegation is that the petitioners, they behave in a very indecent manner. The allegation in the FIR is not specific to the extent that which of the accused petitioner has committed what offense against any of the victims. It is clearly very vague FIR, Your Lordship.
Just a minute. You are appearing?
I am appearing respondent number 12.
Rupasri Borua.
Yes, I am the informant objector. I have raised a preliminary objection regarding maintainability of this petition.
What is the issue of maintainability?
Regarding Lordship, if it was
It was scan record has come.
Yes.
Parties have appeared.
yes,
We can, should we admit it or you want, but everything should not be and cannot be also
yes, Lordship.
disposed at admission stage. Huh?
Yes,
I understand difficulty, but hearing has its own queue. It takes time,
Yes.
whatever it is. But if it is then we can discuss about the maintainability issue.
Yes.
You know, then
My lord,
or you want to let him, he has
My
raised
lord,
it, so let
my-
him submit that.
my lord. And come to the page number 14 of the prayer portion of the petition. In this case, the petitioner have sought for the crossing of the FIR as well as the substitute.
Mm.
But they have not taken, they have not sought for crossing of the cognizance of that. In this case, the FIR was closed on 22/6/22.
FIR charge sheet.
FIR was closed on 22/6/22. And search sheet was submitted 5/8/22. And cognizance was taken on the 4/5/2022. In this case, they have filed this petition on 2025.
Per se, that may not be a.
Yes, sir,
Because
they have not.
they're seeking quashing of the entire criminal procedure,
Yes,
DRC.
In the honorable objection, the Pranjal Kulkarni case. Specifically, and they
So if there is something that I don't know, then I can see it. But otherwise, they're seeking quashing of the entire criminal procedure.
Yes. Selling the into the cognizance of the. Paragraph number no, 8.
I'll come. Paragraph number,
8. Very good.
just. Okay. Yes.
Page number, may I page that?
Yes. It's true, but there's always slightly different thing. When the criminal proceedings, particular criminal proceeding is quashed, then the entire thing goes.
Yes.
Even the cognizance will go.
Yes, so they have today, saying that Congress they have not said anything about the principle. Relying on the government, they are unable to affect the honorable, Allahabad High Court person judges in the defense.
Yeah, then they'll have to make out a case that the charge sheet is not justified.
Yeah.
The charge sheet goes,
Yes.
then the other things will automatically.
Relying on the government of the under Kulkani case, the honorable Allahabad High Court. Paragraph number 12, 13 and 18.
Paragraph 12, 13 and 18.
Yes, sir. Page number 10.
It's okay. So you are primarily agreed by the FIR charge sheet.
As well as the criminal proceeding initiated before the learned JMFC, Your Lordship.
Make your submissions then, preliminary submissions.
Yes, my lord.
Then we'll go into.
So, my lord, after
Time.
filing of the FIR,
Your time. Yes.
charge sheet was submitted, my lord, and the charge sheet is at page number.
We have
20
seen the FIR, right? We've
Yes,
seen the
my
FIR.
FIR is at page number 22, that is type copy, my lord, and vernacular is at page number 24, my lord.
If you want, you can read the FIR vernacular ones. Can you read? Will you be able?
It's a bit difficult, my lord.
No.
Uh,
Oh, this you need not read because we have.
my lord,
I have already read. Some lot of land, so.
there is a dispute of land regarding this family relatives, my lord, in this case. And after completion of investigation, the police had submitted a charge sheet, which is at page number 28, my lord. Charge sheet is at page number 28, my lord.
It's type copy.
Type copy is at page number 26, my lord.
We can read that.
My lord, the second paragraph. By visiting the place of occurrence
No,
during
no,
investigation,
you read whole.
my lord.
You read the whole.
The charge sheet briefly states that on so and so
At
at
12
12 p.m., Rupasri Borua, husband Hitesh Chandra
So-and-so.
Borua, address Vilasipara, ward number
Inform that.
so and so,
has by a written FIR in this police station informed that on so at about 9:30 a.m. the FIR named accused persons, namely Alagas Borua, Biplab Borua, Torali Borua, Anju Borua have, along with some unidentified miscreants carrying stick, shovel, machete, dagger, etc. in their hands with the intention of grabbing her husband's share of land by entering in land without permission and while forcefully occupying the land, her husband Hitesh Borua interrupted them. They attacked her husband in turn by physically assaulting him. At that time, when her son, Luis Borua, an informant, moved towards the place of occurrence, the accused persons inflicted injury on various parts of body by beating with stick, besides attacking with stone, punch, stick, etc., and also did very vulgar behavior by pulling the wearing clothes of the complainant. By visiting the place of occurrence during investigation, the witnesses were questioned, the medical reports were collected after medical examination of the injured persons, and evidence of simple injury by blunt object was found. While interrogating the witnesses, it has come to be known that there was an argument between the injured persons and the accused person, and a minor scuffle also took place, and the accused persons, and there was abuse with vulgar words between the two groups.
I have gone through. No,
My lord.
So, under these lesser sections, this was fine.
Yes, my lord.
293, 323, 506.
Yes, my lord. So the ground which we are taking here, my lord, first one is that the FIR which the informant had lodged, it was at 12 o'clock, 12 noon, my lord. Before going to that, my lord, at page number 39, my lord, at page number 39. My lord, page number 39, that was the FIR lodged by accused petitioner number 4, my lord, against the husband and son of the informant. And this accused petitioner number 4 had lodged the FIR at 10:30 a.m. That is 1.5 hours prior to the FIR lodged by the informant in the instant case, my lord. So we
Page
have
39.
page 39. That is the type copy, my lord. And 40 is the FIR in vernaculars, my lord.
This FIR is lodged by Anju Borua.
Anju Borua, that is accused petitioner number 4, my lord. And this FIR was lodged at 10:30 a.m., my lord. So there was a delay of 1.5 hours in filing FIR by the informant in the instant case, my lord. So she came to know about the incident that her husband was taken by the police. Only after that she came to the police station and lodged the FIR. That was the fact, my lord.
Okay.
And my lord, regarding the charge sheet also, the charge sheet is
Where is the time given? You see.
that is at page number 20. This number 38, my lord. Page number 38.
Information received.
Yes, my lord.
No, 10:30, no?
10:30, we had lodged the FIR much prior in point of time, my lord.
And their FIR at 12.
At 12, my lord. And after that, my lord, the charge sheet which the investigating officer had filed in the instant case, that is also very vague. To the extent that, my lord, what it was said is only that during investigation, as the case is established against the accused persons under sections 294, 323, 506, 34 IPC, therefore, charge sheet is filed before the honorable court. That much only. But there is no specific statement regarding the offense.
That in the narration, even if it is not there, we have to go go to the case diary then.
Yes, my lord.
Right? Are we trying, should we dispose? Parents, so if we dispose, then we have to go inside. The diary materials are available here, case diary materials, because you need statements of witnesses to justify whether now we are seeing whether the charge sheet has been filed with justification. Right? And if yes, I'm coming to your, I'll just address him. If no, from there, if the charge sheet is found to be justified, then your point can come. Then next comes that cognizance should not have been taken. Then he has not challenged. The criminal proceedings, if the charge sheet goes, then automatically the remaining thing will go, right? If I'm not mistaken. So if the charge sheet test is passed, then your point is right. Then he has, but probably he is agreed by the filing of chapter. That is the. So we have to see, madam. So you can show me that according to you, the narration in the charge sheet is fake.
Yes, ma'am.
Fake. The
Because,
case
there
is made out. No, he has said.
Yes, my
that
lord.
On the statements of witnesses, he has said.
Yes, ma'am.
That weapons and machete and all these is not there.
Nothing was
But,
recovered, ma'am.
scuffle was there. This
Yes,
is
ma'am.
there.
Yes,
Even the outraging modesty part has also been
Not there, my
dropped.
lord. So,
We have to see that. Check. Kindly check it because we will need it. Just kindly check it. That's why I mentioned.
CPR
Otherwise,
CPR is here. CP9.
what we need is the. Huh? Check it. That's why I mentioned, because without order sheets, what will you do? Unnecessarily become voluminous. All we need is the case diary.
This is 8 numbers of 8.
Seven.
This is for
Yeah, check it. These sections are 294, 323, criminal intimidation.
Voluntary causing various factors and punishment. Option section from not there.
All are compoundable also.
Yes,
sections.
ma'am.
If they are known from others, they can also think of it. That's for them to decide, of course. Hard. We will call for the case diary.
My lord.
Case diary. Scan copy. And
Let them appear in the trial court. Let them appear in the trial court. Whatever about the contention. Yes. Otherwise, you have the scope for to argue during the court of trial.
these are available of
We-
its own.
we
They
have
are-
not
they
received
are-
the
they are
scan.
bail. When do you propose the next date?
My lord,
Prosecutor. Adam also. When should we fix the next date? It will not be possible in this day. Yeah, after vacation, then I can suggest. Diary will come from Bilasipara.
Bilasi.
No,
Bilasipara.
Bilasipara. JMFC Bilasipara. Injury is a simple injury. Scratch mark for it. But anyway, see. There might be scope for settlement also. I mean, anyway, it's for the- you can try that also if you want. You can try. That. Mr. Basumatari. Basumatari.
Able cemetery.
That counts. SH for additional PP. And Mr. Dr. P. Dr. That's the- On perusing the materials and hearing the councils, I find that the perusal of the case diary would be necessary to ascertain, to adjudicate the contention of the petitioner side that filing of the charge sheet was not justified. However, the same is not available. Issue requisition for, though scanned TCR is available there. Therefore, issue requisition for sending the scan case diary. Charge sheet is already here. Scan case diary and medical report is here. The scan case diary from the court of the learned GMFC, Bilasipara, in the district of Dhubri. Will it be okay if it's after Bihu? Any stay order is there?
No stay order, my lord.
In the given facts and circumstances, further proceedings, till the next date of listing, further proceedings of so-and-so, PRC number 387 of 23, before GMFC Bilasipara shall remain state.
My lord, 928/23. That PRC is 928/23.
Wrong number is written here.
That 387 is the charge proceeding in which we had lodged the FIR.
Then it must be the.
That's correct.
Two FIRs are there, my lord. That we had lodged at 10:30.
Then we have to call fresh. I think 387 is coming. 387 is coming. Just call it order. Call for the scan record of PRC number
928/23.
928 of 2025.
23, my lord.
23, 928 of 23. Sure?
Yes, my lord.
928 of 20.
Yes, my lord.
Comprising case diary. This is a different one. Different one.
No.
Same, but 387 is.
387 is the PRC case in which we had lodged the FIR. my lord.
Which they have lost in it.
Yes, my lord.
Yeah. Yeah. Just check it. Now we'll call for the case diary of which case? There's
928.
Yes, 928.
Okay.
928, which is Bilasipara PS case number
185 of the 20.
Bilasipara PS case number 185 of
2022. my lord.
22. Because it will waste our time if we get it wrong this time. 185 or 20. PRC 920. Comprising case diary. Charge sheet is there?
Yes.
Is here, comprising case diary. Comprising the case diary. So only case diary will. So let it be on the stay, and we'll fix it after Bihu. 28.
Obliged, my lord.
28-1.
Obliged, my lord.
May I please the Lord?
Impugn order. Criminal revision.
Yes, my lord. Impugn order is on page 35.
Page 35.
Yes, my lord. Well, more than 2 years is already is gone, my lordship.
I filed a petition for closing the evidence, my lordship. So,
Page 25.
35, my lord. May I read, my lordship?
Order dated.
Order dated 9/12/2020.
Just a minute. Anyone for the informant?
My lordship. Service has been complete, my lordship. They choose to,
Service has been-
yes, my lord.
The registered post was refused.
No, my lordship. The service has been, they have accepted it, my lordship. Last,
They have appealed.
yes, my, no, they choose not to appear, my lordship. There are observation of the code also, my lordship. And
Where?
no, those are correct.
Because let us clear that part.
Yes.
No, refused. Return to sender.
Yes, ma'am.
Deemed to be so.
Yes, my lord.
They've chosen not to appeal.
Yes, my lord. My lord, I am relying on the judgment, my lordship, which I have annexed, my lordship, on page 26, maybe.
I'll come to. Now impugn order is that? Can you repeat? At page
Impugn order, my lordship, is on page 35.
35.
Yes, my lord.
Yes.
Uh,
9/12.
Yes, my lord. The learned counsel for the accused has submitted that accused is a government employee and prosecution is failed to bring the prosecution witness before this court, and as such accused person needs to be acquitted. The defense relied on judgment passed by the Honorable Supreme Court in the case of Rajdev Sharma versus State of Bihar on 8 October 1998 has made it very clear. In the said judgment, the Honorable Court held in cases where the trial is for an offense punishable with imprisonment for a period of not exceeding 7 years, whether the accused is in jail or not, the court shall close the prosecution evidence on completion of a period of 2 years from the date of recording the plea of the accused on the charges framed, whether the prosecution has examined all the witnesses or not. With on the said period, and the court can proceed to the next step provided by law for the trial of the case. Situated thus, it is clear that the court cannot look into the documents furnished by the learned defense counsel. On the other hand, learned APP has submitted that accused cannot be acquitted on the ground of prosecution witness has not turned up. Now the case is at the stage of trial and this is a warrant procedure case. Hence, the accused petition under 256 of CRPC is not maintainable. Hence, accused cannot be acquitted. He further stated that a bailable warrant was also issued to prosecution witness, namely Azizur Rahman Lashkar and Abdullah Had Lashkar, for non-appearance before the court. Peruse the case record along with the petition. The said petition was filed under Section 256 CRPC. Section 256 of CRPC deals with consequences of
Let's keep this.
Yes, my lord.
Upon perusal of the case record.
My lord. Upon perusal of the case record, it is seen that the case was registered and charge sheeted under Section 341, 325, 294, 34 IPC, and charge was also framed under 341, 325, 294, 34 of IPC against the accused person. The power conferred under 256 of CRPC is to be exercised cautiously by the court, but exercise of Section 256 of CRPC for deciding the present case is not at all tenable as the case is warrant procedure case. My lordship, this is the point, my lordship, which I have raised, my lordship. The judgment which I am relying on does not say that warrant procedure case for it is not applicable, my lordship. Considering the facts of the petition as well as the law involved, the prayer made by the accused in petition number 5821/2024 is rejected. Only the learned APP has taken step upon the said prosecution witness, but no report has received. The concerned OC is strictly directed to execute the process and to and to procure the attendance of the said prosecution witness. Issue fresh bailable warrant of rupees 2,000 each to the prosecution witness, namely Azizur Rahman Lashkar and Abdullah Lashkar. Learned PP shall take steps fixed 17 to 2025 for report evidence of prosecution witness. Now, my lordship, I'll take your lordship to the judgment, my lordship, which I am relying on.
Just offense explanation order is there. The summons case, warrant case.
Warrant case, my lord. There is no.
The charge has been framed here.
Yes, charge has been framed, my
Charge is
lordship.
framed under 341. Just.
It has been more than annexed the case order sheet, my lordship. Charge was framed on 9/9/2022. That is, it has been already 3 years.
Yes.
Page 16 and except 3 may be seen, my
Yes, I
lord.
found here also, the report also. Yes. Under
Page 16 and except 3. Order dated 9/9/2022.
is 60.
16, my lordship. Annex 3. Order dated 9/9/2022.
Yeah.
Accused persons present. Copy is ready and the same is furnished to the accused person. Peruse the case record heard. Finding sufficient materials against the accused person, charges under section 341, 325, 294, 34 of IPC have been framed, read over and explained to the accused person to which they pleaded not guilty and claimed to be tried. Issue summons to the prosecution witness. So, my lordship, from 9/9/2022 to this date of order, my lordship, it is more than 2 years, my lordship. And the judgment which I am relying on, my lordship, I have annexed the
For 2
judgment.
years, no witnesses were present.
No, my lordship, no.
Actually, you are agreed. Anyway, let us see.
Annexure, my lordship, 5 is the judgment, my lordship, I have annexed. Page 26.
I'm coming to that, just checking. Yes.
Page 26, my lordship. This is the judgment which I am relying on. Rajdev Sharma versus State of Bihar. Relevant portion, my lordship.
Referred to by the learned in the impugn order.
Yes, my lordship.
She has also.
My lordship. Impugn order, it is stated that warrant case, it is not applicable, but this judgment, my lordship, it is specifically, it is written, my lordship, page 33 may be seen, my lordship. Page 33, a specific paragraph under para 16 clause Roman I, small Roman I. Page 33, para 16 Roman I.
Yes.
Yes. After deep consideration of the matter, we proceed to supplement the proposition laid by the Constitution Bench in Antole's case with the following directions. In cases where the trial is for an offense punishable with imprisonment for a
period not exceeding 7 years, whether the accused is in jail or not, the court shall close the prosecution evidence on completion of a period of 2 years from the date of recording the plea of the accused on the charges framed, whether the prosecution has examined all the witness or not. Within the said period, and the court can proceed the next step provided by law for the trial of the case. That is my case, my lord. That the case may proceed forward, evidence may be closed, my lordship, because I am a government servant, my lordship. And all the dates, my lordship, I am appearing, my lordship. That is my grievance, my lordship. With these grievances, I have filed this.
Interesting. Yes, but the thing is that this is unqualified because section 256 is applicable in case of summons complaint cases.
Yeah.
The chapter is there. So magistrate took that line. She took that line. That it pertains to summons cases. This is a warrant case.
My lord, warrant case, my lordship. This judgment does not specifically says that it is not applicable to warrant cases. It is warrant case, it is 7 years and more, my lordship. The punishment which has been against the sections, my lordship, it squarely fits in this para, my lordship, clause 16, Roman I, my lord. This judgment never it differentiated between the summons case and the warrant case, my lord.
Point. Thing is that I have not seen the complete judgment, but these are the principles, right?
Yes, my lord.
What,
Obviously, my lordship, if it is written 7 years, exceeding 7 years, it will be warrant case, my lordship.
no, warrant case is different. It's more than 2 years. It's more than 2 years. It's more than 2 years is warrant case.
Warrant.
Yes, up to 7 years.
Yes, my lord. And that is I am telling, my
Get your
lordship.
point. If it's more than 2 years, up to 7 years, it will include warrant.
Warrant
also.
cases, my lord. That is,
But the
that is
chapter
my
256. But no, that means you are not invoking 256. You want to invoke this. 256 applies to summons complaint cases, but he was seeking to invoke this provision actually. No, he wanted to invoke the principle laid down in 16(1).
yes, my lord. That is, I have,
Which
I have
does
read.
not mention about summons or warrant case.
Yes, my
So his case is warrant case.
Yeah.
Magistrate said this provision is applicable to summons case. So no, he said that his contention, I think his case was that he wanted to invoke this provision. So now whether this will prevail over 256,
My lordship.
that is the issue.
This judgment.
I have not come across this dispute.
Yes.
It's new for me.
Ultimately, my lordship, the Honorable Supreme Court is very much clear, my lordship, that after 2 years, the prosecution evidence shall be closed, my lordship. If it is a summons case or if it is a warrant case, my lordship.
No, but then within 7 years, there are many serious cases also.
Yes, my lord.
The prosecution shall close the prosecution evidence of whether the prosecution within that period. That means the outer limit for completion of prosecution evidence is 2 years.
2 years, my lord.
Many subsequent decisions.
No, my lordship.
This
This is the decisions, my
You
lordship.
relied upon this.
Yes, my lord. I have relied upon this. And the learned court below, my lordship, interpreted the judgment in a different way. That is my.
No, that apart, the confusion remains that even if suppose for argument's sake it is not more than 7 years, Suppose that, then will this prevail over 256? You know, I had not encountered this. Interesting point. But
Whether it is applicable in cases of common cases and what.
as I said, no, within 7 years also, leave aside the 7 years more part late. Even within 7 years, there are many cases.
Up to 5 years, cases are generally comes under serious.
Yeah, suppose. Anyway, I don't.
These are all the provisions, my lords, under 16th guidelines may be have been given. If the offense under trial is punishable with imprisonment for a period exceeding
You want
7
to
years
show me,
also.
this thing.
Exceeding 7 years also, there is a provision, my lordship. 16 clause 3, Roman 3, my lordship. From the, in my case, my lordship, 16(1) is applicable. There is 16 clause 3 also exceeding 7 years. Provisions is there, my lordship.
Do some research. I think we'll not be able to complete this today. Naturally, there's a law like this.
Yes, my lord.
If there is a principal law of the Supreme Court like this, you know, without making any distinction between foreign summons cases.
Yes, ma'am.
Naturally, he would like to take advantage of. Naturally.
So whether it is a finding of the.
But 325, what do you say? 325.
325 also we can extend it.
7 years. So 16(1) is applicable as per this judgment, my lord.
Extend to 10 years will be covered by this, not exceeding 7 years.
Yes, my lord.
Law has so many finer points in it.
If your lordship
Amazing.
said any further date may be fixed, my lordship.
Voluntarily causing grievous hurt, which may extend to 7 years. They've chosen not to appear also, respondent.
Here also, my lordship, they have chosen not to appear. And I am a government servant, my lordship teacher.
Should we appoint an amicus for respondent number 2? They have
Yes.
chosen not to appear. The amicus role will be to assist us on this law point.
Actually, not 56. to come, provision to. Okay.
But it's a private thing anyway, so.
Non-appearance or date of complaint. Is separately different footing.
Yes, my lord.
If the summons has been issued on complaint.
Complaint summons case. Complaint summons case.
Complaint summons.
The complaint case, it can be police case, can be these are law school stuff we have, but still we have to keep brushing up these things. Then within complaint cases, it can be warrant complaint cases, can be summons complaint cases. This is a summons complaint case. The next chapter is summary trial.
If the summons has been issued on complaint and on the day appointment, the appearance any day subsequent there to which the hearing may be issued, complainant does not appear. Magistrate cannot be said anything else.
The discretionary power.
Yes.
Yes, my lord.
Unless for some reason.
That is when complaint case. My case is after filing of the FIR, my lordship. That
See, the heading
Here
is
the comment is the public.
but not informant, accused is the public servant.
accused to the No, chapter 20. See, chapter 20. Trial of summons cases by magistrates. Okay. Summons cases by magistrate. Earlier 304A, that was a summons case, but it was a police matter, GR case. 304A was a summons police case, right? But this is trial of summons cases by magistrate.
Here.
Both summons police cases and summons complaint cases. But now he says non-appearance on the date of complainant. When summons has been issued on a complaint, that means it pertains to a complaint case. A summons complaint case. Summons case, complaint case, both. Then this provision is applicable, which the magistrate took this reasoning that this is a
my lord.
this is a warrant case, so this is not applicable. She took that view. But this judgment
He's taken a
seems to prevail over all this. Because it is not, the criteria is sentence, 7 years. I've come across this for the first time, leave me.
16(3), more than 7 years.
If this judgment holds the field, then he's entitled.
From 3 years, I'm going, my lordship, appearing before the court. Even the informant also. Informant never appeared, he chose to not to appear here also.
Otherwise, right, so out of 8 witnesses, 1 witnesses has been
One has been.
After that,
PW1.
after I filed the case,
No, if this
after
judgment,
interim order.
if this judgment has to be implemented, then for all cases up to 7 years, 2 years is the outer limit.
Yeah.
Then many such cases will go. Have you come across this?
But I have to go through it.
Many cases will go. 2 years is the outer limit.
I'm not recent.
Annexes,
With 94 decision, 98 decision, 27 years back. Does it hold the field? Or it has undergone any change?
Might be some changes.
I don't know.
I'm not aware.
I am not aware. This was your petition, right? This
Yes.
was your petition.
Yes, madam.
Has been passed in.
Copy of the petition I have annexed.
No, even if, irrespective of, it's not this judgment does not say that no witness was examined for 2 years. Irrespective of whichever
Yeah.
is there, ends. Anyway, part, keep it part.
Yes.
You also look up.
Yes.
In case suppose we find
Yes,
find
ma'am.
something which is not in your favor, then we'll give
I'll also do some deliberation whether any new material comes, my lord.
that she's trying also, the magistrate, 2000
Yes.
available warrant has been issued also.
Yes.
So within.
My concern is that, my lord,
Within a period.
I'm a government
this,
employee.
They will complete the trial, suppose
Yes.
you do not find out, otherwise if we find that this is applicable and this prevails over other things, then as you contended,
Yes, ma'am.
your contention has to be upheld.
Yes, ma'am.
The third.
SB.
And HS Borana, SH Borana, additional brief. The petitioner counsel has, Mr. Laskar has drawn my attention to order dated 2025, where after noticing the office note dated 26/25, stating that service upon respondent number 2 was refused. The service was deemed to have been complete. None has appeared. The petitioner is stated to be a government servant, and he is facing a trial in GR case, CR case,
GR case, ma'am.
GR case number. Just help me with the
978/2020.
20.
TRC number 888/2020.
Thank you. Where charges has been framed under 341, 325, 294/34 IPC. Why 34? Others are also there. Others?
No, but, my family members are there. My father, mother.
Okay.
Yeah.
Okay. Good stuff. The petitioner is accused has the contention that had the grievance that for more than 2 years the prosecution evidence has not progressed except examination of one witness.
That is after, my lordship.
One.
After I filed the petition, my lordship, after court passed the.
There was one
Yeah,
examination.
after, before, not before, my lordship.
Has not progressed, and therefore in terms of the law laid down by the Honorable Supreme Court in Rajdev Sharma versus State of Bihar. To citation to we have find. The paragraph 16(1), Roman 1, dash, proceedings should be closed. Para 16(1) of the said judgment may be reproduced here in the. However, the learned JMFs took the view that as this was a warrant case, therefore, due to non-appearance of the complainant, due to as well as the warrant case, the provisions of section 256 for closing the case and acquitting the accused would not be, and accordingly, the prayer of the accused petitioner was rejected. Also heard learned additional people. SH for the hearing remained inconclusive in certain law points. Therefore, the matter may be kept as part of. List the matter in January. (28)(1).
Yes, ma'am.
28(1).
Interim order is also there, ma'am.
Interim order passed earlier. The while order dated 15/9/25 shall stand extended till the next date of this.
Right, Lordship. Correction. Page 33, paragraph 15.
Page 33.
Page 33, paragraph.
Wait.
The code of criminal procedure is comprehensive enough to allow the prosecutor to close the prosecution if the prosecution is unable to produce this witnesses in spite of repeated offers.
Yes, ma'am.
Lordship,
This one,
here, the charge was framed on 9/9/2022 and PW1 is examined on 17/02/2023. Thereafter, Lordship, on 24/03/2025, requisition of the scanned copy of the case report was from the High Court.
Yeah.
Till then, perhaps it is not scanned. People in case of experience for the holding of the proceeding and continuous examination of the case.
What did you say that scan copy was called for?
Scan copy was called for the High Court 24/03/2020.
24 to
24/03
2000.
2020.
2000. Okay.
And
Stay was granted.
PW1 was examined on 17/02.
Yes, after that.
after,
After.
After this, application has been made.
Yes.
This time, till the status present with the video note. This is basically what for expeditious trial proceeding. If no witnesses has been examined. No page on this exam. Thereafter, lawsuit.
No, but this judgment says that within 2 years, if the if prosecution, the prosecution, whether prosecution has examined all witnesses or not, irrespective of the stage of the prosecution evidence, this will be done. The only similar provision which comes to my mind, though I have not worked as principal magistrate, recently I had to do a training at resource, so I remember that there is a provision in JJB, juvenile, for petty offences, 4 months, extendable by 2 months, and if it is not complete, proceedings terminated. Then acquittal in that case, acquittal. Here, whatever you have gathered till now, you have to, on the basis of that, you have to, in that it is just ends, the matter ends there. So that comes to my mind when I see that, but within the, as you would agree, within 7 years, many things are there, right? It can be 498A, it can be organized crime of vehicle theft also. It's theft. There has to be some basis, of course. But sometimes a sentence is one part of categorizing the offense. Sentence attributed to an offense is one aspect of categorizing an offense. Apparently, even within 7 years, they can be serious. Suppose you say that this now, of course, new provisions have been added. Suppose you find a network of people indulging in theft of vehicles and selling them to other countries. What provision will you give? It will be theft only. But that will be 3 years. But the nature of the theft is a very serious nature of theft. And stealing as a goat, that is also theft.
Highly obliged, my lordship.
We'll work on it.
Yes, my lord.
File solution. Wait.
Might be lost. Page
16.
High Court. My lord, for page 170, just have a look, then I will take your lawsuit. The question matter of the fire subsequently charges of filing. Page 177. Paragraph
177.
Paragraph 3. 4 months.
Out.
Your lordship, what is point?
Yes.
Now,
It's a bail order.
this is the bail order. Just a gist of that's why I have just. In Tangamada, that was made absolute point. Now your lordship will find my one page 20, my 4 is the FIR. Page 24. What he did, my lord, you all can you see FIR, then I will say my submission. FIR was filed on the basis of a tweeter given by Honorable Chief Minister to the DG.
24.
Page 24.
Okay.
Xerox original page, the podcast to the page 70.
24.
Yes, your lordship has seen that.
Mm.
Now, what he said, my lord, page 73. There was a discussion between one YouTuber and between the petitioner. In the discussion, main subject is matter stock marketing.
Stock market.
Main subject was stock marketing. While matter almost ended, subsequently some question put my general question, page 73, my lord, was what he said, my. It started from, my lord, the discussion started from page, from page 37 it started, that podcast, my lord. Podcast, my between person to person.
Transcript of the podcast.
Yes.
Okay.
This is the subject relating to Assam.
Okay. So page, which page?
Page 73. It starts from page 37. Different question asked on stock marketing, etc.
Page 73.
Subsequently, this is the question, my lord.
23.
Yeah, page 73, you'll also see 56.31. Ria means who was taking interview. She was the YouTuber, she was taking my interview. So here, okay. I am the Abhishek Madam. I am Abhishek Kaur. I am very, renowned that you also might have seen. My name is so many
place internationally, my lord, broadcast, etc., educator, researcher, that I do normally I do. My followers of more than 10 million is mine. Now you look kindly see 56.32. Abhishek, your lordship got it.
Yes.
Abhishek, right. From starting some other things, my lord. Stop it, what was my lord? I'm just like we talked about the Illuminati in the first part. So these big millionaires go to this place. There is a worship happening around the old idol. That is fine. But suddenly what they saw there, it seems like a child's sacrifice was taking place. 56:46. This is the portion relating us. Abhishek. So this is a question. So there are practices, I am saying, my lord. There are practices happening which have been happening for a long time. And may be people won't believe them. But all these things are happening. For example, if you go to Assam, by the way, I am saying, my lord, it is not my intent. For example, if you go to Assam, there is a place where they say the girls of that village have such powerful spiritual abilities and they have the power. So and so, as a human, you go there and they can convert you into goat and other animal, and at night they turn you back to human being, and so and so, so and so. Because there are a lot of tantric practices whose roots come from here. In fact, if you Google it, you will find that there is a village. Its source is Google, my lord. It's not my source, I am not. So there is a village where this happens. Well, now there are a lot more educated people here. In fact, the story goes that once when a whole army from the Mughal Sultanate came there, it disappeared overnight. They could not even attack. They were able to attack everywhere, but not at that place, that is Mayang in Assam. I think it was in Mayang or somewhere like that. So there are places where dark things happen. So you ask, a billionaire is spiritual. Its such jobs is visiting Nim Kerala Baba, the noun person.
Irrelevant talk.
Yes. He is my lord, and that is temple, Hindu Guru, my lord, he is a Guru. Then, my lord, if Mark Jumanwa, he is the, my lord, Facebook owner. He is visiting Nim Kerala Baba. If Mukesh Ambani is doing a big charity at a South Indian temple, if Amitabh Bachchan is going a large charity in South Indian temple, if Nita Ambani is receiving something during a match, I think we have enough evidence to say that billionaires do practice this. Open your eyes. You work for 15 hours and then to open your eyes. So he is also not supporting these things. Open your eyes and we see what is there. This is the case against him. On this basis, my lord, Honorable Chief Minister, page 157. Page 157. 157. Your lordship. Good. One 57. 110. Your lordship got it. Here, on our Chief Minister Assam, a video from a YouTuber channel named Ria. I am not Ria Mail. Ria is in circulation. An individual named Abhishek. I am Abhishek. Who is seen making unacceptable comments on Assam's history and tradition. Appropriate action may be initiated against the said individual for spreading misinformation. Then, thereafter, my lord, DGP, next page. GPC notice, sir, lawful action shall be taken, warm regards. According to thereafter, my lord, what he did, that your lordship kindly come to page. I have opened the my apology also.
154.
On hearing that, 154, your lordship, 154, 155. When I came to know that it is in circulation and people is misinterpreting it, I made it issue a public apology, my lord. Your lordship got 154. My lord, in the midst of that, here, be ready to face Assam police. Your lordship got it. Page 154, middle, small,
Yes, 154 I've seen.
154, middle, my lord, be ready to face Assam police.
This is a comment.
Comment. Then what he says, my lord, hi, this time stamp information is probably hurting people. Would suggest to remove this. I would issue an apology. Thereafter, your lordship can read next page, 155. Your lordship got it, 155. Abhishek Kaur.
Okay.
You also got it, man. Apologies to the people. CM Assam, I have given copies to all my lord, that every concerned party who was hurt, the intent was not to hurt anyone, and it will be kept in mind going forward that such incident don't happen again. That I have stated. So thereafter, my lord, the whole things come, my lord, whether the section L, whether these are attracted or not. Basic is, my lord, witch hunting, main, my lord. That it was registered in the section, your lordship will find.
Which hunting?
Section, it was copy is an extra. 9. One copy may be there, madam, given the sections along with all the definitions also. One 196, RDR 155 3A IPC, RDR.
150,
Now
3A.
RDR 153 AMI IPC. Now it is 196 BNSF. Then section 197, present one, RDR 153B IPC. The BNS is
197 one is
197 RDR 153B, my
B.
capital B. Then my 353. Section 353.
Subsection 2.
505, RDR 505. That is conduct public mischief, my. Then thereafter, my lord, information technology 67, that is your lordship know that information. Then your lordship Assam Witch Hunting Prohibition Act, Assam Act. Extra.
Section 67 is transmitting.
Section 67 of the information technology. Punishment for publishing, transmitting obscene material in electronic form.
Obscene material.
Obscene material in electronic form. Then your lordship will find Assam Witch Hunting Section 4. Witch hunting. Assam Witch Hunting. Nice, huh?
Otherwise, you can find it on the net. Section.
It will look. Okay. This is an examination book, my lord.
Part of exam.
Somebody, one of my juniors collected it, my lord, who appeared.
Which hunting is
Witch
real
hunting.
problem. It exists. Gradually, it is decreasing.
Yeah. Section 4.
Definition.
This is definition. This one. Section 4. No person shall identify, call, stigmatize, defame, or accuse any other person as which by words or by signs or indications or by conduct or actions or any other manner or instigate, aid or abet such an act or commit witch hunting. Whoever identifies, calls, stigmatizes, defame, accuses either by words, signs, indication, conduct, action, or any other manner, any person as which instigates or aid or abet or any such act mentioned in clause subclause 1 above shall be punished with a term which shall not be less than 3 years, may extend to 7 years. And definition, you will also kindly see, definition is, which definition is, my lord? 2GH.
2G.
2GH, my. 2GH. G, which means any person who has been supposedly identified, called, stigmatized, defamed, accused, at dining, Diana, Dakini, Dakan, Booth, Buthumi, or any other such name by person or persons under the grip of a unrealistic and unfounded impression that such person has the power to harm anyone or society at large.
Yes.
Witch hunting means the identifying, calling, stigmatizing person by signs, indications, so and so involves as well. So everything is done, whether it has heart, whether I knowing it did, or it is in public domain, my. This Mayank, it is in public domain. I have simply narrated, my lord, the what offense I have committed. 153A, whether it has come, no reaction from any public.
153B is imputations to national integration.
B, my lord,
What is B?
the B is 153A, 196. First 196, 197. BNSS, idea 153A, promoting enmity between different groups on grounds of BNSS and BNSS,
Yes, I've got it.
but or IPC, anyone will do.
Content is same.
Yes, sir.
I've got it.
Yes. Promoting
I got
enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. Promoting enmity, your logic, whether any enmity, whether anybody has been hurt, whether anything happened, any communal riot happened.
Okay, so now 197.
Then 97
is the,
imputations,
national integration.
assertions, prejudicial to national integration. That is also not there. Your lordship.
Yeah. And 353.
Then 53 statement conducting to public mischief. Whoever makes, publishes, or circulates any statement, false information, rumor, report, including through electronic means, with intent to cause, your lordship, with intent to cause or which is likely to cause any officer, soldier, sailor, airman, navy to mutiny or otherwise disregard or fail in his duty as such, or with intent to cause, or which is likely to cause fear or alarm to the public, or with intent to incite, which is likely to incite any class or community. Then subclause 2, whoever makes, publishes, or punishment part shall be punished, extend to 3 years. Now, whether any of the ingredients are present in the present case, whatever he is saying in an interview, somebody is putting some question, and after many questions, he has come to some other question. I said that this is all public domain, my lord. In my petition, I have stated, my lord, which are the basis on which I have made this statement, my lord. Petition of appeal. Yeah. No, apology letter.
Based on
Huh?
news articles.
Yes. Your lordship will find. No, that is the investigation. Also pay. You can read it. You can have the one I have later. You are the Hmm? Oh, 153. Reason going to 2025 SCC online. Just ingredients on 153A. Paragraph 9.
153 days a very old case from Kashmir. It's still Bilal Kadzu, Bilal.
Not Imran Pratap Goel.
That's still.
Now it is latest one, 25.
That judgment is still referred to.
Yeah, exactly.
That Bilal, I'm forgetting the full name.
Yeah.
Bilal.
Manzar Sayyid Khan. Madam, page, paragraph 34. Ingredients of Manseria here, madam. 30, 35, 36, No, 34 to the year.
Para 34.
My intention, what is my, that Mansiga lordship very much aware of that part, my. In the case of Manjar Sayyid Khan and the case of Patrika Mukim versus State of Meghalaya, the ingredients of Mansiga has been read
Meghalaya.
to section 153A of the IPC, by which this court, paragraphs 8 to 14 of the decision in the case of Javed Ahmad Khajan, that I might be your lordship is mentioning that, which analyzes both the above decisions read thus. This court in Manjar, to view taken by Vivian Bose, Justice, as a judge of the Arswell Nagpur High Court, in Bhagavati Charan Shukla case, a division bench of the High Court dealt with the offense of sedition under section 124 and so-and-so, press release so-and-so. This issue was whether a particular article in the press stands directly or indirectly to bring hatred or contempt to the government established in law. This court has approved this view in a decision in Ramesh so-and-so. In the said case, this court dealt with the issue of applicability of section 153A. In para 13, it was held. Thus, the effect of the words must be judged from the standard of the reasonable, strong-minded, firm, and courageous man, and not those of weak and vacillating mind, nor of those who sense danger in every hostile point of view. It is the standard of ordinary reasonable man, or as they say in English law, the man on the top of the great man mind. I am here, I am a podcast. I do not belong to any of the high, Dangor man or yeah man, my only question, I was in a discussion, casually I made this statement. That is my case, man. Casually I made the statement, and that is based on, that is in public domain. From Google I have searched and then paragraph 10 also, my your lordship may be seen. Paragraph 10. Now, coming to back section 153A, your lordship got it. Back to section 153A, clause A, subsection 1 of section 153A is attracted when by words, either spoken or written, or by sign, or by visible representation, or otherwise, an attempt is made to promote disharmony or feelings of enmity, hatred, or ill will between the different religious, racial, language, or regional groups. We come in the regional groups, or caste communities. The promotion of disharmony, enmity, hatred, or ill will must be on the grounds of religion, race, place of birth, residence, language, etc., so and so, so and so, so and so. So 153 will apply only when an act is committed which is prejudicial to the maintenance of harmony between the different religious, social, language groups and disturb, or is likely to disturb the public tranquility. Nothing happened, no reaction from the public. Only my lord CM, Honorable CM has made a tweet, and that basis they might have registered. I have nothing to say, my lord. My question, my lord, whether anything happened. What was my intention? What for I did it, my lord? So, my lord, in my opinion, my lord, is it a case to be quashed, my lord? There is the abuse, nothing but abuse of the process of the court of law. And your lordship kindly say my petition paragraph, page 12, my lord. Just have a look, my lord. I will not take much time.
Para 12.
Page 12 of my petition. Just to show that it is not my words, that I have collected from other source, my lord. Page 12. Paragraph, page 12. Page 12, man, starts from the statement, lordship got it. One, the statement made in the podcast were based on publicly available references from reputed sources like Ask The Pen, Times of India, and various academic articles. The petition neither introduced nor endorsed any unverified or harmful claims. The statement made in the podcast were misinterpreted by a section of public. This misinterpretation cannot form the basis for a criminal charge and no evidence has been presented to prove the deliberate so. The petitioner's statement, when viewed in full context of the podcast, if starts from A to B, my lord, A to Z, then the petitioner statement, when viewed in full context of the podcast, do not advocate or promote witch hunting or any illegal or harmful practice. The podcast was purely focused on stock market education and business awareness, and any misconstrued segment was entirely unintentional. So that what has come, that was really under. So this is, I think, my lord, my submission from my side, my lord, subject to what my lord and say, my. I think it is a case not to proceed with. And I am from Bhopal, my lord, from Madhya Pradesh. Madhya Pradesh, so that is also one way it might abuse the process of court, otherwise also my is hard stuff to me, and whose ultimate result will be whether if there is any chance of conviction, my lord. Basically, my principle of Bhajanlal and subsequent cases, my lord. What is the ultimate aim, my lord? Whether it will be a case of conviction or not. If prima facie is found acquittal, my lord, then I think your lordship may interfere. No victim, none of them, not a single person has made any statement. And nothing happened also. It is a casual, just a in between discussion.
Anyway, so
I lift your lordship. Oh,
Here, my lord, yes, my lord, the PCR is the PCR, my lord, that is the entry of the my lord, that is the case diary, my lord, that is the endorsement. That part is not available. Other than that, my lord, is the actual report from the video, the statements of the witnesses, my lord.
but the this
Those things,
the offending statements are this much only, no? Which is in paragraph 56.46.
That much only, but my lord, before that, my lord.
No, I'm
you
just
make
because
any-
I also have to understand it.
Yes, my lord.
The initial initial problem started with this.
started from page 35, no?
Page 73, 56.46. Right?
But it starts from page 37. Whole discussion starts, my. In the last part about this
No,
question.
the whole discussion is not relevant.
Yes, yes.
The
Assam, so far Assam.
the comments which allegedly offended and led to this.
Yes.
It's in this part.
My lord, for that reason, my lord, may I, my lord, pray to once again, my lord, go to the perusal of the FIR, my lord.
Yes.
The FIR with lodged, my
That one will go.
Because two things I've noticed here actually.
My lord.
That if you go to Assam, there is a place where they say, he says where they say.
Yes.
Where
I'm
they say.
coming to that, my lord.
And
Before
then
that,
he
my lord,
says,
the content of the FIR, my lord, that the which is got, my lord.
anyway, so page 24.
My page FIR, no?
I go back to 24.
Page 24.
Okay. Our note is collected.
My lord, may I read, my lord?
Yes.
My lord, that with reference to the subject cited above, I have the honor to report that one Abhishek Kar through the YouTube channel of Twenty4 has published a video where he has commented against Assamese women, mentioning that Assam there is a place where girls practice black magic, witchcraft, and can convert human beings into goats and other animals, and later at night they can convert them to human beings and establish physical relations with their last. Abhishek Kar has made derogatory remarks against Assamese women deliberately with the malicious intention of outraging the modesty of Assamese women. He has also spread misinformation about culture of Assamese society, which may lead to breach of peace and tranquility in the society. The person, namely Abhishek Kar, with an intention of criminal conspiracy, has attempted to promote malicious and disrespectful information about Assamese society, giving totally wrong picture of Assamese society, thus leading to promotion of disharmony and feeling of hatred between the people of different communities in the society. Therefore, I request you to register a case under proper section of law for further investigation against Abhishek Garg, an owner handler of YouTube channel, so and so for the offense mentioned. Now, my lord, here is the case. The case, my lord,
Is that Miss Upreti or something? No?
my lord, her statement is available.
Is she an accused?
My lord, her statement is available.
But she's not an accused.
No, not mine. Because my lord.
Because they have,
after completion of the investigation.
Charge
Charge sheet is laid against my lord.
She's not an accused. He's the only
She's not
accused.
an accused, but she is one of the my lord witnesses.
Witnesses. But because why I'm asking this question is
Yes.
because they have said there is criminal conspiracy.
Yes,
Criminal conspiracy.
Right.
There has to be
I-
more than one person.
yes. My lord, I'm coming to that. Now, my lord, what my limited understanding is that it is a case of my lord social media. It is not that my lord there is a quarrel between my lord that is the neighbors or some my lord people my lord, but it is a recorded thing in the social media my lord, and it is a kind of my lord promoting the hate speech. My lord. It's not about the free speech my lord. It's about the hate speech. Number two, it is a misinformation my lord. My lord, I'm not coming to the my lord that is the social media age. My lord, that is a long ago, my lord, because of my lord, this is the history says that one my lord news is my lord broadcasted from All India Radio and a massacre happened, my lord. This is the history, my lord. Now, my lord, in the time of my lord social media, when from a YouTube seminar, what is my lord published, my lord, automatically, my lord, that is my lord going on, my lord, told by many people, my lord. If such information, my lord, coming, it is not a case that in the place of Mayong, my lord, somebody is hurt. It is a case, a people from that particular state, if he leaves any part of the country, my lord, if somebody says, and because of that misinformation, anything may happen, my lord. That, my lord, part, we cannot, my lord, say that there is no possibility of that part, my lord.
No, the thing is that the ingredients of this section
My lord.
that to spreading rumor to cause social communal tensions
My lord.
between communities. Which
My-
two communities? Because in Bilal that case, the Honorable Supreme Court has said that for the applicability of 153A,
My-
one of the most fundamental requirement is two communities must be involved.
My lord.
There must be involvement of two communities.
My lord.
So that so he is instigating against this community. A is this torturing this community.
My lord.
So that kind of statement can happen. But here, you see, he does not even say Assamese woman. He says in so area of Assam.
Right.
Not even he later says about now, but in Assam, and there is an area they say
My
that he's they can do this thing. He does not even say Assamese women. In Assam, only Assamese women do not live.
My- my-
All communities live.
Yes,
isn't it?
but my lord, when my
If you define Assamese women
Yes,
narrowly
my-
by mother
Yes,
tongue,
my- that's true. my
otherwise
lord.
all
But
are Assamese.
The thing is that my lord, the arena is social media. my lord.
Yeah, that's true.
Arena is social
That is
media.
true.
my lord.
We see the hazards of social.
Yes, my lord.
No doubt
That's
about
what,
that.
my lord. That,
But at the same
I
time,
don't
there are
know,
two things actually.
Yes.
There are two things.
Fine.
This is a kind of little general comment, but still
my lord.
not completely irrelevant to this case.
My lord.
Otherwise, our own machinery will be really harassed. We must have mechanism to to control fake news, because fake news can create a lot of problems.
My lord.
We must have mechanism to prevent dangerous rumors which can
My-
harm society.
my-
But then that apart,
My lord.
that apart, there are hundreds of podcasts, hundreds of people are speaking all the time.
My lord.
So suppose somebody makes like how many well, no, after how many people can I get running?
My
This
lord.
because already overstrained machine.
My lord.
Right.
My-
So what I'm trying to say is that while we must have this mechanism to prevent instigation of offenses, instigation of this social this rumors and all these things, riots and all these things, false issues. At the same time, this is a very important realization that I have also personally had, that in the times of widespread electronic communication as well as social media,
Right.
our threshold of tolerance for of freedom of expression, the freedom
Right.
of expression limit must also become elastic.
My
It
lord.
must be expanded,
My lord.
because this was not there 50 years
Right.
back.
My-
This was not there. As you said, radio,
Right.
TV, Doordarshan
My-
was always there. Now there are hundreds of modes,
Yes.
YouTube. So what would constitute a violation? What would constitute a reasonable restriction? That what is not permissible within free speech? What happened? What was correct 40 years back is no longer correct today. Today our threshold, I would say, has to be much larger. That's why. Otherwise we have to keep running before this person, that person, that person. Ignore some things. We have to ignore. And today morning also I said mentioned one thing. Our society, our community, our country, these things are not so fragile that somebody makes a comment like that and we'll all start fighting amongst ourselves.
Nowadays,
And then the country will be big, and it's not like that. The country, the society, the state is much more strong. That it's not fragile anyway. So in this larger backdrop, because these problems, believe me, will keep coming.
Yes,
There will always be people who will make some wrong remark somewhere.
And my lord, because of these issues, regarding hate speeches and all, my lord, the apex court also.
No,
my lord, very much concerned.
hate speech is not. Hate speech is bad. Hate speech is how do you define hate speech? That it invites, it tries to create feelings in me, for another person or another community to harm that person. Go and harm that person.
Yes, because my lord, here, my lord, that is the
Yes,
transcript, my lord.
yes.
May I read, my lord, one part of the
Yes.
transcript, my lord? My lord, because it is available in the report, my lord. For example, असम में आज भी आप जाओगे तो एक जगह पर है जहां पर कहते हैं वो गांव है, वहां की लड़कियां को इतनी ज्यादा सिद्धियां हासिल है कि दे हैव द पावर कि आप इंसान बनाकर जाते हैं हो, लेकिन कन्वर्ट यू इनटू ए बकरी और और एनी अदर एनिमल, और रात को वापस आपको इंसान बना के संभोग करती है.
Now, till then it was okay. The problem started with the last part.
Mine.
The problem started with the last part.
Why? Because there are lot of tantric practices. Jiska root.
I'll tell you, the whole thing started with this.
With
word.
this something.
When this sexual relation part came, now that started the problem.
Mine.
Otherwise, somebody says
Mine.
that he has the power to transform
Yes, mine.
me into a tiger or
Mine.
some rhino
Mine.
or something.
Mine. That is ironic.
For that, that will people will take it jovially.
Details, my lord, in our childhood, we all, my lord, listen.
Even one of my domestic help has told me that he seriously has seen in his village that one person being converted into a tiger.
Mine.
Of course,
These are
when he was
stories,
small.
my
Now
lord.
he's
So our
grown up.
trainings also, my lord, we are.
And the Mughal Sultanate was also, my lord, kind of so powerful we are here.
He's a very
Yeah, we
lovable
prevented
person,
them.
part of our family.
Yes.
But I sometimes tease him still about that. Anyway, so but the problem started with this. That after converting into animals, then
That is
At this stage,
started.
my humble prayer before your
Somebody might be offended. No, I may say something harmlessly, but somebody might be offended. That I do not deny his right to be offended. But as you said, this judgment which shows the test of a reasonable person, not test of a hypersensitive person, not test of a insensitive person, also. Not hypersensitive person, test of a reasonable person, right? So the sensibilities were offended, whatever. It was this note was taken that this is offensive. This might be taken as offensive to people of women of Assam. Women of Assam may find it insulting. This started because of this later part. In my humble opinion.
my friend has very beautifully explained my lord. Hindi also very well I communicated. Very much Hindu ভাল কৈছে Hindi. But Amish Devgan very important 158. So
None of us have any right to insult anyone and
No,
insult.
that only
community.
can take a
Community
license,
is
man.
even bad, even
Yes,
worse.
yes, ma'am.
Everybody has entitled
And then
to respect.
paragraph 96 of Amish Devgan, madam. That is also very important. Paragraph 96. This is also 153, 158 differences are also. My only question, madam, once he has given public apology, saying that it was unintentional if any it hurts anybody, my lord.
Para?
Paragraph 96. Other phrases also there, but basically this thing, ma'am. Very, very important judgment. Mr. Devgan, that also he is also my lord.
Heard about this.
That is-
Vinayak Gopal
Yeah.
Godse.
There are many judgment also referred, madam, in this case. तो हिंदी सपोज है दोबारा और हिंदी बोल जाए हाँ ठीक? हाँ, दुनिया हिंदी का मैं तुम्हारा कोई वो
But hate speech is a serious matter. Hate
Yes.
speech is, if something amounts to hate speech, it must be prevented.
For that reason, my lord, my respect for your lordship is there. At, my lord, at this juncture, my lord, this honorable court only received, my lord, that is the statement along with the other reports. But my lord, that the endorsement,
The Bilal Ahmed.
case diary is very much needed. my lord.
Which endorsement? The
My lord, that is the case
Tokas.
diary, but entry of the.
Tokas, Tokas.
Yes, my lord, Tokas and all.
But
Because-
record was also come, my lord, because charge sheet file.
Because my lord, in this case, my lord,
Tokas are
22 numbers of PWs they have examined. There are some people from the area, my lord, that is the affected area.
yeah, naturally. So
And
many
there
people
these
must
things
have
are
heard.
there, my lord, along with these things. I think answer, my lord, may I pray for my lord, that is my lord, for the my lord, that is the case diary, my lord.
Anyone examined from Morrigaon district? No, you are not aware.
Yes, my lord, they are examined, my lord. I have done for those, my lord, witnesses also.
My Bilal
My
Ahmed
lord,
Khan is also there, my
that
lord.
you involving, my lord, that is the challenges, my lord, during the time of my lord.
Yes.
On the paragraph 97, that Bilal Ahmed, your lordship noted, that is also mentioned. 96, 97. Bilal Ahmed Khan. my-
But I tell you, I read it again.
Your lordship, my lord,
The
your
whole
lordship.
problem started with these 4 words.
Yes, my lord. Yes,
These 4 words.
yes, my lord.
The last part.
And that is in the FIR, my lord. That is in the
The last
FIR,
part.
That is a part of the FIR, my lord. And my lord, we cannot, my lord, make it that, my lord, that because of that, my lord, nothing will happen, my lord. Because many things may happen, many things may
Anything
not
happened for last 1 year. 1
May
year
not
already
happen
passed.
also, my lord.
My lord,
And
1
may
year already
happen-
passed, my lord. 1 year. Anything happened. Enough time, my lord. 1 year, almost 1 year.
Anyway,
1 year passed, I made public apology. It is a discussion. Anyway, I left your lordship, my lord. I think I have a case. And charge sheet also there, my lord. Records also. Records also.
could you continue?
It will record.
Could you continue? Yes, sir.
Record one.
You need
That
one
CD
more
is
day?
not available, my lord. Other race part, my lord, I have, my lord, submitted, my lord.
Completed.
Yes, my lord. Because, my lord, this is a, my lord, the,
According to the prosecution,
area, my lord.
it should, instead of quashing, it should be allowed to be proceeded there.
Yes, my lord. And, my lord.
Now, whether my lord proceeding, my lord, ultimately.
No, that's his contention.
Yes. That my lord, he is, I'm not
His
saying.
contention, his contention.
My question, if he proceeds, my lord, ultimately it is abuse of process of court of law.
No, that is your contention.
That is my contention. And ultimate conviction chances there or not, my lord. If any chance of my lord conviction, certainly my lord lordship may not quash my lord. But here is a case, my lord, no, none of the ingredients of any section. That is what I am saying, my lord. 1 year already gone, nothing happened, no complainant, not a single person.
What is the stage of the case?
It is just charge sheet.
Appearance.
Not yet charge sheet, my lord.
Cognizance, not taken.
Search may, my lord.
Yes.
At that point, my lord, search may be.
What
my
is
lord,
the record
my
which has come? Record.
lord. That may be.
Do I have the case diary?
My lord, that part is not available. Only we have the statements, my lord. My lord, but the endorsement, my lord, the notes are not available.
Because if I reserve it and finally. Look at that video. Statements are there, no?
Statements are there. Even 183 statement of that, my lord, that is a. That is also, my lord, there, my. If, my lord, my humble submission is that my learned senior has submitted my, if it is not, my lord, stand for trial, then also, my lord, there is a mystery.
Should we ask for the full set of the CD?
So that may.
Because if I reserve it and I find that I need some more materials, then I'll have to again put it to be spoken to that is,
Fine.
Statement of Caesar witnesses. Should maybe sufficient also. All the statements are there.
All statements are there, my lord.
And charge sheet is there.
Charge sheet is there, man. Charge sheet is there.
That is
My lord,
enough.
the FSL, all things are there. Transcripts available with us, my lord.
That is enough, I think, my lord.
This much. Transcripts are also here.
Transcripts are there, my lord. I have flag mark, my lord. All the transcripts.
Should be able. In case I face handicap, then we still have that option. To be spoken to option. To be spoken comes on the list. Then again, we have to take it back.
But otherwise, my lord, this material are there, my lord.
Another judgment for 3 and
We can keep it for one more day. For any
one more day, what I think.
clarifications from his side. Whatever. Toka, I don't know, without seeing, I cannot say.
Then, my lord, that is the next part we can come to know during the course of investigation, what they found. Because the.
No, this is already there. Whatever they found in investigation, it is before your lordship. Now trial stage, they will come, that is evidence, etc.
Third learned senior counsel for the petitioner. Gave also additional PP for the state. Arguments concluded, judgment is resolved.
Visible. Obliged to your lordship. Subsequent judgment given, my lord, and other, your lordship, Bilal Ahmad is there in 97.
That's why I'm resolving. It will take
My
some time. See,
Well, in the
Obliged.
meanwhile, prosecution may be also allowed, my lord, if we, our side, if we
Sir.
also, my lord,
Both is there.
submit, my lord, authorities, if we get,
you want to submit?
my lord.
Can submit. No problem. What's the problem, you know, they're trying to dispose of, because other matters are, orders I could not touch.
Obliged to your lordship.
The mentions, I think. Mentions. Take the mentions. Take the mentions.
Okay. May please, your lordship. Lordship, in this matter, in the last occasion, TCR was called for. However, lordship, as per office note dated 8/12/25, TCR has not been received yet.
In this case, TCR may not be authorized, subject to.
No, that I cannot say no, without going into it.
Thing is there, they have filed this petition on a technical ground, my track was given Jimma to me, They are, saying that as per custom act, trial court, has not the restrictions to grant Jimma or reject Jimma. It is there to consider.
Customs.
Yes,
Their
customs.
This is their.
Lordship, this will require some more time actually.
We have to submit, otherwise, vehicle is being damaged, in long time, we have not just to file application before them also, already you have also.
No, I cannot decide now, no, this only for the
Lordship, TCR may be called.
paucity of time.
Kindly a short date will be. Vehicle is already there.
After vacation,
Kindly, track is already.
not before vacation. How can I manage? No? No possible, only for the bail. Next week is motion. Motion week, new matters. Call for the TCR. That's a case record as called for not yet received. Issue reminder for the same. Interim order shall continue.
Deeply obliged.
He'll give you the dates.
Any date may.
He'll give you the date.
Lordship, in item number 18, Lordship, next item.
Yes.
Lordship, we have filed an IA for correction of the cost title. Lordship, there is a simple inadvertent error, Lordship, typographical. In place of ACBPS case number 44 of 24, it should be ACBPS case number 7 of 2025. In the cost title.
18.
IA was.
Only in the cost title.
Yes,
Correct.
Every.
Okay. Oh, sorry, you instead of ACB PSK 44, actual should be ACB.
PS case number 7 of 2025.
Incorrect. Disposed of.
My lord, I am for item number 14, my lord. I am lax at port number 2, my lord. That's why I will appear.
Yes.
So next week, your lordship.
After vacation.
Date may be fixed, my lord.
After vacation, he'll give you the date.
Yeah, please.
Orders.
Mr. I beg to mention item number 39.
Yes.
The delay condoned application, the delay of 11 days, and my learned friend is appearing.
Yes.
For the respondent number 2, Lord. The delay may be condoned, appeal may come for.
No, I cannot say. No, I don't have the file. Don't have the file. Take the date. Short dates you take.
May be the lordship in item for.
Because you take the paucity of time. No? Paucity of time. No, you take a date. Because it's not possible without the file. It's not possible to pass orders. Madam, yours.
Lordship, in item 45, service report is awaited on respondent number 2. In this case, what happens, Lordship, I have praying for quashing of the FIR as well as charge sheet. In the meantime, Lordship, learned trial court is proceeding and next date is on 2/1. There is no
2/1,
stay of
sometime
the
available.
proceeding. So before that, next week, if your Lordship. Item 45.
Okay, take it. 18,
May I please lordship, in item 40,
15,
18.
18.
may I please lordship, in item 40, my lord, and the last occasion, my lord, amicus curiae was appointed, my lord, his name should be shown, my lord.
Amicus curiae for?
For my lord, respondent number 2, my lord, his name should be shown, my lord, and my lord,
Amicus curiae.
there is an, my lord, there is an order, my lord. After receiving the LCR, my lord, my interim pair will be considered. So long back, my lord, LCR
No,
has
I
come, my
won't
lord.
be able to absorb because I'll make, because I
My
don't
lord.
have the file. Kindly take the dates.
My lord.
He'll give you the dates.
May I please
Possibility of
have-
time, we'll take it up.
My lord, my lord.
Wait, one
Just a
submission,
minute. একটু আগে লাগাই দিও, okay, ফুলে যাবে।
May I submit? Lordship?
Yes.
In item number 15.
Yes.
Lordship, that P. Ramachandra Rao judgment regarding the
Huh.
trial proceeding. So that's, there is a, that judgment has been overruled by another judgment.
Oh, yes, yes.
On 30th.
That's why I've never come across this corporation. That's 7 years, if it's, it has to be closed.
Submission, Lord.
No, I think
Item
you,
number
I think you may be right. You are right, I think.
day after tomorrow or?
Yes, yes. I'll tell my law clerk also.
May I please, your lordship? Small submission. May I
Yes,
please? Item number 38, your lordship. Orders 38, your lordship. We want to take fresh steps upon the, your lordship, 2, 3, 4 respondent, your lordship. Kindly allow to
Fresh
take
steps
fresh
on
step
respond number 3 and 4.
2,
Fresh
3,
step
4.
2,
2,
3
3,
and
4. Your lordship.
Without the file, it's very difficult.
38.
2, 3 and 4. Kindly take that. He'll give you that. So don't worry. It's paucity of time. We'll take it up again. In the same form.
Hold on.